Hello, hello, hello. How's everybody doing? I don't know why I start out with those on. Doesn't make no sense. Anyway, how's it going? Welcome to Rush to Judgment with Jessica. And I'm Jessica. Hey, how's it going? Everybody doing okay? Good morning, good afternoon, good evening. It's been a wonderful day. And we are gonna finish this trial. This is the end. This is the end of the Alexander Jackson trial. I don't even think we have to break it up that much. And I think we can fast forward through most of it if I am not crazy here. So, anyway, yeah, that's what we're gonna do. Because we're going to get through some jury instructions, we're going to get through closing statements from the state, and we're going to get through closing statements from the defense, and then probably rebuttal from the state in their closing. And then it will get sent back to the jury. And then, since we don't have to do jury watch because, I fell behind and whatever, and it's about a week late, and everybody already knows the verdict, or whoever watched it already knows the verdict. We don't know the verdict. I don't know the verdict. And so we're going to watch it together. So that's how that is going to go. Yeah. Did I do my little intro? I don't know if I did. Anyway, well, let's just start this over. We'll just say, hey, welcome to Rush to Judgment with Jessica, and I'm Jessica. Hey, girl, hey. If you're new here, welcome. If you're returning, welcome back. And yes, I already said what we were doing. We're gonna finish the Alex Jackson. Why did I say Alex Jones? Oh, because there is a whole Alex Jones, and he did the things with the things, and yeah, okay. Well, this is Alex Jackson, and then there's Alan Jackson, Alexander Jackson. But then there's an Alex Murdaugh trial going on. It's confusing. Don't get me wrong. But this is the last day. This is the last one. And then we can do whatever we want. I don't have anything on the docket at the moment as to what to do. I have some little ideas that I've thrown around in my noggin, but I'm not 100% sure just yet what I want to do. So, I don't want to do that. I just want to do that. So, we're just going to get right into it. And I think we get right into, I think I got it to where we're starting out. They went over some jury instructions that they argued about back and forth. And then I think we're just getting right into, jury, where they bring the jury in and instruct said jury. Oh, well, and if you haven't been watching, I guess I'll give you a little rundown. But I'd prefer if you go back and watch, but that'd be cool too. But I mean, because you can't just come in at the season finale and watch it and be like, oh, okay, that's what happened. Because that doesn't make any sense. Nobody does that. I mean, I do read the end of the book first, which is weird. I don't know. Because I end up having too many questions. And then sometimes in shows, like if they've already run through and I'm watching and there's like 6 seasons and it's questionable what's going on, I will sometimes Google it and get spoilers. It's a flaw. I accept that. It's fine. But so Alexander is on trial for allegedly killing his mom, dad, and younger sister. So he's being charged with 3 counts of first-degree murder, and that is what he is on trial for. They've arrested, state's arrested, defense is arrested, everybody's arrested. They've gone over jury instructions, and now they're bringing in the jury to go over so the jury can hear their instructions, and then closing arguments, and then we wait. But we don't have to wait. Then we just get into the verdict because we don't have to wait. So yeah, that's it. That's all we got. That's what I got for you. And also another reminder, I am not here to really give any type of education on this matter. I am here to give my opinions and my thoughts, really. And sometimes I'm smart, and sometimes I say some smart things, and maybe I'll tell you something that you didn't know before. Or sometimes, I say dumb things and have questions that I don't know the answer to. And then sometimes I'll Google it and find the answer midstream. It's whatever. Or, it's just purely entertainment and commentary. I do not specialize in any type of legal mumbo jumbo. I don't know anything other than what I watch on the YouTubes with the other lawyers on the YouTubes that watch the trial and give their actual educated thoughts. I'm just a regular person. So I'm more like a juror person instead of a legal mind. I do know some legal things, but not to the extent that the other people know. But anyway, so yeah, just throwing that out there. So if you're looking for like education on things, that's probably not the channel for you. You can probably go check out the people in the LawTube genre to get that information. But none of them covered this trial. So unless you want to just go watch it on the Law and Crime, just with nothing and their commentary, that's fine. But I think I'm probably more entertaining than nothing on Law and Crime. But that's just my opinion. Anywho's, we're just going to get into it because I've been talking for about nothing for a minute now. Okay, let's go. Let's move me down here. Let's make sure we got them closed captioning. We are at a little bit of a faster pace. And we can press the play. No, that's them. It's not me. It's them.
All right, go ahead and have a seat, everybody. Good morning, ladies and gentlemen. So on your chairs, you had an additional stack of paperwork this morning. Those are a copy of the jury instructions. So each of you will have a copy
of those. Copy of it.
Follow along with as I read those to you. You'll be able to take
dog
those
is
back
wandering around under the desk.
You'll also get the original
Hold on, I can turn this up
by myself, along with the verdict forms. Those will be sent back to you. So just at this point, I'm going to read to you the first 35 instructions.
That's
instructions after that, I'm going to read to you after closing arguments are completed.
Okay.
And you may notice and wonder why, but at some point, Kathy is going to stop taking notes. There's no need for her to make a record of something that a record already exists of, so it's redundant. So she'll stop.
Yeah, Kathy.
Now, when I start reading the jury instructions.
Okay.
Ladies
And
and
I
gentlemen,
just kind of like to listen to them because
accuses the
they
defendant of the crime of 3 counts of murder in the first degree.
give
The
you
charges the
definitions
defendant
of things that you might not know.
on or about June 15th, 2021, in the county of Lynn, state of Iowa,
Again, I don't know
did, having
all
malice
of the
aforethought, willfully, deliberately, and with premeditation, kill Jan
legal
Jackson,
mumbo
count
jumbo.
1, Melissa Jackson, count 2, and Sabrina Jackson, count 3, at 4414 Oakleaf Court Northeast, Cedar Rapids,
We get a
County,
different
Iowa.
angle
Each of the 3
today.
counts of the information include the lesser and included offenses of murder in the second degree and involuntary manslaughter. To these charges, the defendant has entered a plea of not guilty. Upon the issues thus made, you
So
were
he does have
instructed as
lesser
follows.
charges too.
Instruction number 1, the trial information is the document that formally charges Alexander Jackson with a crime and is merely the method by which he is brought into court for trial. It is not evidence. Instruction number 2, Alexander Jackson is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of Mr. Jackson. The presumption of innocence remains with Alexander Jackson throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 3, Alexander Jackson has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you, the state must prove something. It must be by evidence beyond a reasonable doubt. If the state does not prove Alexander Jackson beyond a reasonable doubt, your verdict must be not guilty. Instruction number 4, the burden is on the state to prove defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, and not the mere possibility of innocence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of defendant's guilt, then you have no reasonable doubt, and you should find defendant guilty. But if after
So proof beyond a reasonable doubt, not proof beyond all doubt. Now, a reasonable doubt is the intruder. That was their explanation and their reasonable explanation. And the jury has to then decide, well, did the state prove that beyond any reasonable explanation, he committed these crimes? Personally, and again, it's not about whether or not it's not about whether or not he didn't do it or he did do it. It is whether the state proved that he did it. Because somebody could be completely guilty of whatever it is that they are accused of, and yet the state did not prove it. But here we go. Normally, it's been very rare that it comes back not guilty and stuff like this. Like, because people don't look at the facts, they don't look at the law. People judge with their emotions. And since I've been watching trials more and looking at things from a more legal standpoint, and actually, instead of listening to like the media and reading stuff and just watching what goes into the trial, I've noticed that my brain focuses more on what's being presented at trial than, all of the speculation outside of the trial and all of that. And it is harder. So it's not harder, but it leaves it up to legal standing instead of by your gut. I mean, and most people, they don't look at it like that. And a lot of times people are convicted based on other people's intuition, or like not maybe not intuition, but just like their gut feeling. So I don't know.
For a full and fair consideration of all the evidence or lack of evidence produced by the state, you are not firmly convinced of defendant's guilt, then you have a reasonable doubt and you should find defendant not guilty. Instruction number 5. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 6. You shall base your verdict only upon the evidence in these instructions. Evidence is testimony in person or by deposition. 2. Exhibits received by the court. You may examine the exhibits closely, but be careful with them. 3. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes, during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to, which were not offered and received in evidence, are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers. 2. Objections and rulings on objections. 3. Any testimony I told you to disregard. 4. Anything I tell you as part of these instructions is not evidence. And 5. Anything you saw or heard about this case outside of the courtroom. Instruction number 7. Certain testimony has been read into evidence from a deposition. A deposition is testimony taken under oath before the trial and preserved in writing. Consider that testimony as if it had been given in court. Instruction number 8. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence or circumstantial evidence or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 9. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, 1. Whether the testimony is reasonable and consistent with other evidence you believe. 2. Whether a witness has made inconsistent statements. 3. The witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4. The witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 10. During the course of trial, you have heard testimony from various officers regarding statements allegedly made to them by neighbors and workers in the area where these crimes occurred. These statements were not offered for the truth of the matter asserted. Therefore, you may not consider the statements allegedly made by neighbors or workers as evidence in this trial, and may only use the statements to consider the conduct made by officers in response to the information they received.
Then why did you even put them in there?
You have heard testimony from persons described as experts. Persons who have become experts in the field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Instruction number 12. In this case, Alexander Jackson has decided not to testify. He is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of Alexander Jackson.
He pled the fifth.
Evidence has been offered to show
He
that the
said,
defendant
no, thank you.
2 video interviews with the police on June 15th, 2021. If you find any of the statements were made by the defendant, then you may consider them as part of the evidence. However, the statements and questions of the officers during those interviews are not evidence and may only be considered by you as context for the defendant's answers. You have also heard a recording of the defendant during a 911 call. If you find that those statements were made, you may consider them as part of the evidence. Instruction number 14. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person know the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 15. Count 1. The state must prove all of the following elements of the crime of murder in the first degree. On or about the June 15th, there's an extra "the" there, but on or about June 15th, 2021, the defendant shot Jan Jackson with a firearm. 2, Jan Jackson died as a result of being shot. 3, the defendant acted with malice aforethought. 4, the defendant acted willfully, deliberately, premeditatedly and with a specific intent to kill Jan Jackson. If the state has proved all these numbered elements, the defendant is guilty of murder in the first degree. But if you find the state has failed to prove any one or more of the elements, then you should find the defendant not guilty of murder in the first degree and proceed to determine whether the defendant is guilty of murder in the second degree as defined in instruction number 16. Instruction number 16, count 1. The state must prove all the following elements of the crime of murder in the second degree. 1, on or about June 15th, 2021, the defendant shot Jan Jackson. 2, Jan Jackson died as a result of being shot. 3, the defendant acted with malice aforethought. If the state has proved all these numbered elements, the defendant is guilty of murder in the second degree. But if you find the state has failed to prove one or more of the elements, then you should find the defendant not guilty of murder in the second degree and proceed to determine whether the defendant is guilty of involuntary manslaughter as defined in instruction number 17. Instruction number 17, count 1. The defendant must prove all the following elements of involuntary manslaughter. On or about June 15th, 2021, the defendant recklessly utilized a firearm. 2, the defendant did the act in a manner likely to cause death or serious injury. 3, by doing the act, the defendant unintentionally caused the death of Jan Jackson. If the state has proved all the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter, and you should find the defendant not guilty as to count 1. Instruction number 18, count 2. The state must prove all the following elements of the crime of murder in the first degree. On or about June 15th, 2021, the defendant shot Melissa Jackson with a firearm. 2, Melissa Jackson died as a result of being shot. 3, the defendant acted.
I'm sorry, are we both?
4,
sir?
the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Melissa Jackson. If the state has proved all these numbered elements, the defendant is guilty of murder in the first degree. But if you find the defendant has failed to prove any one or more of the elements, then you shall find the defendant not guilty of murder in the first degree and proceed to determine whether the defendant is guilty of murder in the second degree as defined in instruction number 19.
Now we got to go through all of them with all of them.
Instruction number 19, count 2. The state must prove all the following elements of the crime of murder in the second degree. 1, on or about June 15th, 2021, the defendant shot Melissa Jackson. 2, Melissa Jackson died as a result of being shot. 3, the defendant acted with malice aforethought. If the state has proved all of these numbered elements, the defendant is guilty of murder in the second degree. But if you find the state has failed to prove any one or more of the elements, then you shall find the defendant not guilty of murder in the second degree and proceed to determine whether the defendant is guilty of involuntary manslaughter as defined in instruction number 20. Instruction number 20, count 2. The state must prove all the following elements of involuntary manslaughter. On or about, I'm just crossing out those extra thes on mine and initialing them. So on the original, it'll be correct. On or about June 15th, 2021, defendant recklessly utilized a firearm. 2, the defendant did the act in a manner likely to cause death or serious injury. 3, by doing the act, the defendant unintentionally caused the death of Melissa Jackson. If the state has proved all the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter, and you shall find the defendant not guilty as to count 2. Instruction number 21, count 3. The state must prove all the following elements of the crime of murder in the first degree. On or about June 15th, 2021, the defendant shot Sabrina Jackson with a firearm. 2, Sabrina Jackson died as a result
See,
of
and the
being
thing
shot.
is,
3,
like,
the defendant acted with
why
malice aforethought.
though?
4, the defendant acted
I
willfully.
know they don't
deliberately,
have to
premeditatedly, and with a
prove
specific
a
intent to kill
motive,
Sabrina Jackson. If the
but
state has
with
proved all these numbered elements, the
but
defendant is guilty of murder in the first
why?
degree. But if you find the state has failed to prove one or more of the elements,
They're going
then
to
you
tell
shall
you
find the
why
defendant not guilty of murder in
in
the
their
first
closing
degree, and
arguments,
proceed to
because their
determine whether the
closing
defendant is guilty
arguments
of murder
aren't
in the second
evidence,
degree, as defined
and
in
they don't have
instruction
to
number
prove their
22.
closing
Instruction
arguments.
number 22.
So they can
The
just
state
say
must
whatever
prove
the hell
all
they
the following
want.
elements of the crime of murder in the second degree. On or about June 2021, the defendant shot Sabrina Jackson. 2, Sabrina Jackson died as a result of being shot. 3, the defendant acted with all these elements of guilty murder in the second degree. But if you find the state has failed to prove one or more of the elements, then you shall find the defendant not guilty of murder in the second degree and proceed to determine whether the defendant is guilty of involuntary manslaughter as defined in instruction number 23. Instruction number 23. The state must prove all the following elements of involuntary manslaughter. On or about June 15th, 2021, the defendant recklessly utilized a firearm. 2, the defendant did the act in a manner likely to cause death or serious injury. 3, by doing the act, the defendant unintentionally caused the death of Sabrina Jackson. If the state has proved all of the elements, the defendant is guilty of
Yes,
involuntary
he
manslaughter.
unintentionally
If the
went
state
room
has
to
failed
room
to
and
prove
slaughtered
any
his
one of the
family.
elements, the defendant is not guilty of involuntary manslaughter, and you shall find the defendant not guilty as to count 3. Instruction number 24, murder in the second degree at instructions 16, 19, and 22 does not require the specific intent to kill another person. Instruction number 25, as used in instruction numbers 15, 18, and 21, Willful means intentional or by fixed design or purpose and not
Sorry
accidental.
if you can hear the
Deliberately
dog.
means after having deliberated, which is to weigh in one's mind, to consider, to contemplate, or to reflect.
Hope
Premeditate
it is
is to
not
think
too
or ponder
distracting.
upon a matter before acting.
If
Deliberation
she
and
doesn't have a
premeditation need
bone
not
to chew
exist for
on,
any
she'll
particular
eat the
length of time
carpet.
before the act. Instruction
And
number
she keeps
26.
puking at
Malice,
3
as used in
a.m.
instructions 15 and 16, 18 and 19, and 21 and 22, is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person
Injurious.
appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed design, which means a fixed purpose or design to do some physical harm to another, which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 27. Malice aforethought may be inferred from the use of a dangerous weapon. Instruction number 28. Serious injury, as used in instructions 17, 20, and 23, is a condition which cripples, incapacitates, weakens, or destroys a person's normal mental functions and or a bodily injury, which creates a substantial risk of death or which causes serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ. Serious injury includes, but is not limited to, skull fractures and rib fractures. Substantial risk of death, as used in instructions
feel like they got shot in
17,
the
20, and
noggin.
23, means more than just any risk of death, but does not mean death is likely. If there is a real hazard or danger of death, substantial risk of death is established.
There was substantial
Instruction number
risk of
29.
death.
A person is reckless or acts recklessly, as used in instructions 17, 20, and
I
23.
would hate to read
when
all
he or
this.
she willfully disregards the safety of persons or property. It is more than a lack of reasonable care, which may cause unintentional
If
injury.
anybody on
Recklessness
here
is
has
conduct
watched
which is
any of my
consciously
videos,
done with a willful disregard of
words are
consequences.
hard.
For recklessness to exist, the act must be highly dangerous.
Words
In
are
addition,
hard
the
and
danger
reading
must be
this
so obvious
hard.
that the actor knows or should reasonably foresee that harm will more likely than not result from the
Not
act. The
easy.
recklessness is willful. It is not intentional in the sense that harm is intended to result. Instruction number 30. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner, is capable of inflicting death. It
You
is also
can
any
use
sort of instrument or
any
device actually used in
instrument.
such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. You are instructed that a firearm, such as a .22 rifle, is by law a dangerous weapon. Instruction number 31. If a person
would say
has the
so.
opportunity to deliberate and uses a dangerous weapon against another, resulting in death, you may, but are not required to infer that the weapon was used with malice, premeditation, and specific intent to kill. Instruction number 32. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may,
So you
but not
cannot.
required to,
You
conclude
do
a
not know
person
what
intends
was
the
in his
actual
brain.
results
You
of
have
his
to look
acts.
at the evidence.
Instruction number 33. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all the instructions together. No one instruction includes all the applicable law. As you consider the evidence, do not be influenced by any personal sympathy, bias, prejudices, or emotions. It is common to have hidden or implicit thoughts that help us form our opinions. You are making very important decisions in this case. You must evaluate the evidence carefully. You must avoid decisions based on things such as generalizations, gut feelings, prejudices, fears, sympathies, stereotypes, or inward or outward biases. The law demands that you return a just verdict based solely on the evidence, your reason, and common sense, and these instructions. As jurors,
Do
your
not
duty is to find the
rush
truth
to
and justice.
judgment.
Instruction number 34. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 35. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. All right, ladies and gentlemen, I'm going to read the remaining instructions once we're done with closing arguments. So at this time, counsel for the state and counsel for Mr. Jackson will have an opportunity to present to you and make closing arguments. I believe Ms. Slaughter on behalf of the state will go first. Then Mr. Johnson will have an opportunity to make his closing argument. The state will also have then a chance to make a rebuttal closing argument after Mr. Johnson is done. During the closing arguments, I expect that the attorneys will be in part summarizing the testimony that you have heard and the evidence which has been presented. In doing so, they're going to be recalling that evidence and testimony as you will be later doing.
Don't
Neither
misstate
one of
the
them will be intentionally
testimony.
trying to mislead you, and if their recollection of testimony or evidence is not the same as yours, you should rely on your own recollection or testimony if you believe that's the accurate version. The arguments that counsel are making,
try
the
to
summaries are
mislead
merely
you.
that. Again, they are not evidence. They
Bullshit.
should not be construed by you as evidence. I anticipate that one or both of them may also talk to you about the instructions and the law. Again, what they tell you is not the law. The law that you are to apply is what I've given you in the instructions and will give you in the final instructions. The arguments that they're going to be making in the summaries are intended to help you in understanding their respective positions, and you should give them both your careful attention. And with that, Ms. Slaughter, are you ready to make your argument for the state? You may. Ms. Slaughter, do you need the no laptop? Okay. All right. You could tell by my gesturing. All right.
Her hair is much better down. I'm glad we get to actually see them. It's on. You don't have to look so aggressive. Don't look aggressive.
June 15th, 2021.
Start out. Good morning.
Alexander Jackson makes a call to 911. In that call, immediately after the phone is picked up by the dispatcher, he says, someone broke into our house. Our address is 4414 Oakleaf Court Northeast. I've been shot. My other family member's been shot. I need help immediately. That phone call started a chain of events. Ladies and gentlemen, after the last several days, you sat in this courtroom and you heard testimony from several witnesses about the events that unfolded the morning of June 15th, 2021. What you heard was that during that phone call, dispatch got on the phone, got on the radio, and immediately sent officers in the direction of the Jackson household. And the officers arrived. With limited information that was provided through the 911 call, they took up location and parked their vehicles up the street for safety purposes. They had brief conversation. They discussed their strategy for approaching this house.
And then they rang the doorbell.
And with the information that they had initially received from dispatch,
for a break-in,
immediately felt like something was off. Something's not right. You heard two officers through their body camera microphones suggest that maybe this was even a swatting call, that someone had made a prank call and attempted to get emergency personnel to respond to this house. It didn't sound right. The officers are seen and heard on their body cameras relaying information and receiving.
No, they thought it was a bullshit call, and it ended up being a little bit more serious than what they thought.
See if you can get the mom or the sister to come outside. Simultaneously to those communications occurring with dispatch, Alexander Jackson is still on the phone. He says that he's been shot in the foot, that someone broke in, he's been shot, his dad's been shot, he was shot in his left foot. When asked by the dispatch operator who shot him, who broke in, his response was a man. When asked how this man got into the house, Alexander Jackson's response was, I think they came in the back door, but I'm not an expert.
Isn't that your job?
When asked who he was home with, the defendant said that he was home with his sister. She was in her bedroom. But never in that 911 call do you hear the defendant yell out to his sister, Sabrina, I've been shot. Dad's been shot. Are you okay? Nothing. And the reason the defendant isn't calling out to his sister is because he knows that she's dead. He doesn't call out to his mom. Mom, I've been shot. Mom, are you okay? Mom, help me. Check on dad. Because he knows his mother is also dead.
Fair.
When the 911 dispatcher attempts to get more information, the defendant says he's black, and the dispatcher asks, his shirt or his skin? Both. So now we have a man with a black shirt who's black, and that's all we've got.
And green shoes.
Do you know if your mom and sister are safe? Well, I don't see them. They should be safe. Remember, ladies and gentlemen, that when officers finally felt that they could make a safe approach to this house after Officer Brown perched up in the trees because the door was open and there were several windows, and the other officers made the decision that the door was open so that they needed to enter. Remember where Alexander Jackson was sitting when those officers came in? You can see it perfectly on Officer Brown's body camera right about 7 minutes and 55 seconds. The defendant is literally sitting outside of his sister's bedroom. The only thing that separates her room and his room is that small wall, and he's sitting right there holding his foot. But he doesn't know if his sister is safe. Throughout the call, the dispatcher goes on to ask Alexander if there's any guns, any
He's
weapons
bleeding.
left. And Alexander Jackson tells the dispatcher, well, there is a gun on the floor.
He didn't realize how much shooting himself in the foot was going to hurt.
But we got shot with it. And you can hear the inflection in the dispatcher's voice because even she's caught off guard. And she says something along the lines of, you got shot with your own gun? Yeah? Question mark. Officers come in, and immediately upon entering that back door, they see Jan Jackson laying face down in a pool of his blood in that downstairs lower level living room.
Yet they still ask to see his hands.
The person on the floor initially is the caller, or you hear Officer Buckles through his body cam asking the person on the floor to show him his hands. But Jan Jackson could not show his hands because Jan Jackson was dead.
He was
and you see officers come in. They come in and they start to do a protective sweep. They're checking back rooms. They're checking storage rooms, anywhere big enough for a person to be.
They did not check that house.
Down the hallway,
That's what they did not call that. They did not check
you
the
hear him
house.
yell out, we've got another one. We've got another victim down here, another dead body. And that dead body was Sabrina Jackson, laying in her bed under the covers with what officers believed was only one gunshot wound to her left eye. The remaining rooms downstairs were checked as officers made their way up to the main level of this home and continued their protective sweep, checking the garage, checking the kitchen, checking all of the rooms, the closet, before they made their way around the back of that stairway into the master bedroom, where they found Melissa Jackson's body, also deceased, laying on the floor. Pile of blood on the bed, and then blood on her person and her final resting spot. Based on the information that was being received from Alexander Jackson, K-9 Officer Buckles made the decision that he was going to check the area, track the area, to see if they could catch the scent of this alleged intruder. And you see it. The dog goes out, makes a stop in the same area where the vegetation is disturbed, where Officer Brown was crouched down by the trees, follows through the trail, sniffing and tracking, and picks up another scent along that path along the back of the house where officers had come around the backside of the house. Officer Brown,
because that was the most recent
the hospital
track.
Defendant, and you can hear and make the determinations and judgments based on what you heard in that video of the statements that Alexander Jackson made.
No, you couldn't, because you couldn't hear shit.
Route to the hospital.
But okay.
Investigator Bosenberg first goes to the hospital, photographs the defendant, takes pictures of the injury to his foot, takes some swabs, and then he returns to the house. And he returns to the house to process the scene. And you heard from Investigator Bosenberg that there are certain methodologies and protocols used when any crime scene is being processed, and that there are some variations to those protocols depending on the size of the crime scenes and how long it can be held. You know, there's a difference between a crime scene in the middle of a road that needs to be opened back up and a house that you can secure and hold for 4 days. But essentially, what Investigator Bosenberg testified to is that over a 4-day period, he and his partner processed the residence at 4414 Oakleaf Court Northeast. And ladies and gentlemen, during the processing of that evidence, what you saw is that behind the couch, just inside of that lower level living room, just inside of the door, was a pile of shell casings. And throughout the investigation, you came to learn some things about the murder weapon in this case and the specific ways in which it ejects spent shell casings out of the bottom in a group opposed to ejecting out of the top and throwing them. A pretty tightly grouped pile of shell casings laid right behind that couch.
That
You
weren't
also
tested
saw
for
photographs of
fingerprints or
Investigator
DNA.
Rosenberg as he progressed his way down the stairs. And it was very obvious from the evidence that as Jan Jackson left his office the morning of June 15th, leaving behind his cup of coffee and his half-eaten muffin to come downstairs, that the defendant was perched up behind that couch and started shooting his father. One shot to the neck area, one shot
So Dad
right
was
chest.
first.
One shot to the left temple. You saw one shot, which was evidence tent 17, was a missed bullet hole. You saw minimal blood spatter at the bottom of the stairs.
Oh my God, she said it right.
And then Jan Jackson fell. He fell face first into the carpet, right at the base of those stairs. And then the defendant, for good measure, stood over him and put 2 more bullets in the back of his head. 5 shots in total for Jan Jackson. 1 missed shot into the wall.
So
6
that's
bullets.
6.
We found out during autopsy from Dr. Kelly Cruz
7,
that
8.
Sabrina Jackson had more than the original believed bullet shot just to her eye, that there was additional wounds that were discovered under the blanket. The initial shell casing that was found in Sabrina Jackson's room was right by the door. In order for that bullet to travel the path that it took into her left rib, out of her right-ish abdomen area, and into the arm, she had been laying in a position that was visible and exposed to the defendant when he shot her from that doorway. Dr. Cruz testified that though that shot could have killed her, it's very possible that she would have been able to roll over after that initial shot. And that's the exact position that her body was found in, ladies and gentlemen. After being shot through the rib and out of the abdomen and back into the arm, she rolled over into a fetal position. And the defendant got closer and shot her in the eye. I say got closer because the second shell casing was not found during the initial search. And Investigator Rosenberg explained that when they process a scene, they go through and they find the very apparent and obvious evidence and they mark it. And then they start to peel back like an onion. I think he described it, the layers of the crime scene, finding additional evidence. So after enough was done with the bodies that they were confirmed to be deceased and put into their body bags, which were then locked and transported to the medical examiner's office, another shell casing fell out of that bedding. And it was seen next to that or behind that teddy bear. 2 shots, 2 shell casings found in that room. That's 8. What you saw next is that Melissa Jackson's bedroom, or the master bedroom that she and Jan Jackson shared, was processed. And what you saw in those processing photos is that right when you walk in the bedroom door, again, there was a very neat cluster or grouping of spent shell casings right inside of that doorway, indicating that several shots were fired from that specific location. And you saw those rods, those wooden dowels that were used and placed in the headboard to give some idea of the trajectory, and those pointed right back at that doorway. What we saw in that master bedroom is that 3 shots were fired.
8, 9, 10, 11. Didn't it hold 11?
At Melissa Jackson as she laid in that bed. One of them grazed her scalp, likely the injury that caused the blood found on the bed. And then she rolled out of the bed. 1 more shot from a distance to her temple. Her right temple. And then a final shot, point blank, into her left eye. And you saw evidence in that case, or in that shooting, of that very close, that stippling, as Dr. Cruz referred to it, and as that soot and that burn powder that had burned into her skin, causing that discoloration. inches away from his mother when he shot her in the face. On top of the soot and the stippling that were seen in the injury, there was that extra shell casing that didn't quite fit in the group, found right in between Melissa Jackson's legs, that would have shot down with a slightly forward angle as it was discharged from that .22 caliber Browning. The defendant wanted to make sure that each one of his family members was dead. Now, during the interview with the defendant, he told investigators where he was at when all of this was happening. The 5 shots that were fired off in the master bedroom, the 6 shots.
Oh, you just said there were 3. Now there's 5.
Jan Jackson, the 2 in Sabrina Jackson's bedroom, and the defendant, he was outside, sleeping on a screened-in porch in a sleeping bag with his dog when all this happened. And though Investigator Bosenberg testified that .22 caliber is one of the smallest weapons on the market, I think he said there was a 17 caliber that's not used or isn't customary, but the .22 is small caliber weapon. But even though it's small, you know, and it isn't as powerful, doesn't shoot as loud, you would think that gunshots, especially that many, would wake the defendant. And he testified that he did get woken up by them, that he got woken up by gunshots. He heard approximately 10, and that he ran downstairs and saw.
He looks like a pretty heavy sleeper back then.
Man in all black, who is a black man messing with a gun standing over his father. Alexander Jackson says, I ran at him.
Didn't hear him
pushed him.
Say he was a black man.
I tried to take the gun. Then, well, you see what happened.
Yeah, he shot me.
Investigator Lucina tried to tie the defendant down to some more detail, and the defendant remained very
tried to tie him down
that he was willing to offer. And I submit to you, ladies and gentlemen, that the vagueness in the defendant's story was intentional. And you'll see that as the interview progressed, that vagueness, those open holes that were left in his original story, he was slowly able to fill with additional detail as those additional pieces of information helped him tell his story. You hear that this black man wearing black.
She gets angry every time he's
then had on green shoes.
Black man.
Then you hear that this black man who was tall, wearing black clothes and green shoes, now has on a black ski mask. And then approximately 12:55 in the afternoon, as officers are talking to the defendant about how the gun got into the living room in the first place.
Your memory comes back a little bit.
The defendant conveniently puts gloves on the intruder. Investigator Bosenberg,
if you're going to break in a house, you should probably wear gloves.
Before he ever moved the firearm, that he did some processing of that weapon right there on the scene. That he took some initial swabs, and he explained how the buccal swabs are 2 in a package, and you swab and then you put them back, and how that evidence was collected. But he testified that there were some specific locations on the firearm that he wanted to test before moving it, potentially contaminating it, to make sure that he preserved the potential for DNA to be found on that firearm. Now, ladies and gentlemen, the defense is going to stand up here and they're going to tell you that the state failed or the investigators failed to test all the swabs that came off of that gun.
All because they did.
But I submit to you that the additional swabs that were taken were done in a speculative nature, where the original swabs that were taken at the scene by Investigator Bosenberg were taken of parts of this firearm that were guaranteed to have been touched. Guaranteed to have touched that trigger at least 15 times. And this isn't just a brush of the trigger. Pulled, tension, pulled that trigger at least 15 times.
Gloves on, it wouldn't have left
Swabbed
any DNA.
the location where the bullets are loaded into the gun. Had to have happened. The defendant, during his interview with investigators, says that he unloaded. First, he's not sure where the gun was stored before the gun got into the living room, where he and his father, the night before this, decided that out of the blue, they were going to clean this weapon because the last time they had used it, some umpteenth time ago, that this gun jammed. So he's not sure where the gun came from. But the gun gets brought into the living room, and when he's asked if it was loaded, he mentions that he was putting the bullets back in the box, that he was unloading this weapon. And when investigator Lucina pressed on, is there going to be anybody else's fingerprints on these bullets? No, I don't think so. There shouldn't be. The intruder had gloves. She said, well, you didn't say he had gloves before. And the defendant said something along the lines of, well, I didn't say whether he did or didn't have gloves, did I? He knows there's not going to be anybody else's fingerprints on the bullets because he is the one who unloaded the gun. He is the one who reloaded the gun. He is the one who reloaded it again. The DNA swabs taken from that firearm were processed
Don't mock
by the DCI
the
lab.
defendant. Makes you look petty.
Not only did they not return any DNA profiles for an unknown person, unknown intruder, they didn't return profiles for the defendant either.
Well, it looks like your lab is shitty.
Touch DNA that we heard about. Investigator Denlinger testified that in all of his years of history and
All
doing
of his
investigations,
years of
that
history.
he doesn't get touch DNA. And Mr. Johnston brought up another case in which he claims that the DNA was from touch DNA because it didn't come from a wet spot or a stain. That doesn't make it touch DNA. No DNA from this gun. And the investigators, based on the lack of DNA from the specific 5 places that were guaranteed to have been touched, made the decision not to send the other swabs in. Over and over,
That was dumb.
the defendant was asked questions about what happened that morning. Where were you shot? Downstairs. Never really says where he was shot. Says that he tried to take the gun
Who was shot downstairs?
from this supposed intruder,
She must not have teenage or adolescent boys.
and that either he shot himself in the struggle or this
You have
supposed
to ask
intruder shot him
very
in the foot.
specific questions.
Within 30 seconds of being shot, he claimed that he called 911 and that he had to go into his bedroom to get the phone, to make the phone call. The defendant, through his statements during that interview, wanted the police to believe and want you as jurors to believe that on this night and into the morning, this hot night that's causing Corsa to pant, where it's too dangerous for this canine dog to do her job, that the defendant at 320 pounds is outside sleeping in the heat in a sleeping bag with his dog with no phone because his phone's downstairs in his bedroom. And that's where he had to crawl to get the phone to
I
call
was wondering
911.
when somebody was going to bring that up.
Except investigator Denlinger testified that there was activity on the defendant's phone during
At
the 6
6
a.m. hour.
At 6.
Clear up to, I believe, 6:57 or 6:53. Check your notes.
Well, maybe
where he's
he was sleeping in his
Googling
room
things
and he
and
got up.
he's on
at
this
6
social
and
media app called
he
iFunny.
back up the porch,
There's all
didn't
this
you?
activity on the
That's
phone.
fine.
And we're supposed to believe that somewhere between him playing on his phone, he gets his phone into his bedroom from the porch, makes his way back up to the porch and lays down and goes back into a sleep so sound that he doesn't hear his family being
He's
executed.
320 pounds. He has probably got some sleep apnea issues. Come on
You
now.
heard Investigator Bosenberg, ladies and gentlemen.
And those who live in brick houses
Talk
or
about
glass houses should not throw bricks.
The part of his job
Water.
where he test fires weapons.
We's not them,
That
girl.
when firearms are recovered, he's responsible for test firing those firearms. And that in a year's period, he does 80 plus guns. And that in his career, he's fired hundreds of different weapons. And you heard him testify that as part of the processing of this
Get
22 caliber Browning,
to
had
it.
test fire it as well. And in order to do that, he had to load the firearm. And what he found when he attempted to load that firearm is that this specific Browning rifle was so unique to him.
He didn't know how to load it.
That he had to watch a YouTube video on how to load this gun.
Oh, God. You're not telling me
And you
anything
saw
I don't remember
portions of
for
that
real.
YouTube video that investigator Bosenberg watched. This isn't
It is an
typical
odd gun.
as far as how this gun is loaded. You saw that in the buttstock of that gun, there was
Buttstock.
something you got to twist, and then you got to pull out this pole, and then there's a hole in the side of the gun where you've got to pump a bunch of bullets, and then you've got to work this stick pull thing back into the gun and turn it.
Objection misstates the evidence.
And that was done twice by this intruder. Once to load the gun because Alexander Jackson said that it was unloaded when he left it at the fireplace. And then again after he ran out of those 11 bullets. And there was some conversation about the processing unloaded? Of those bullets and the
he said he didn't remember.
And firing pin impressions and them being ran through the Nibin system. And somewhere when this person from ATF, I think somebody who was contracted through the ATF, I think investigator Bosenberg said, when she hit the drop down to pick the 22 caliber rifle, she selected short. But he told you that the shell casings from the scene of the crime were longs. And the long and the short makes a difference, right? Because of how many bullets can be loaded into this gun at a time. And we took a recess and he told you that during that recess, he conducted an experiment with the actual bullets found at the scene, the 22 caliber long bullets found at the scene, and that during that experiment, he could not load more than 11 bullets into this gun. And he testified about the size of the long being around 16 millimeters, which is significantly longer than the shorts, which is around 10 millimeters. That gun on June 15th was loaded with longs. The longs are what was found. The shell casings that were found were longs. There was an error in that report from the drop down. 11 shots, over 15 fired, 3 left in the chamber. That gun had to be reloaded, ladies and gentlemen, by this intruder.
All right.
Investigator Denlinger talked to you about gunshot residue. Gunshot residue being kind of a damned if you do, damned if you don't test for it situation. And he explained that the state lab in Iowa, which does criminal analysis for the entire state, stopped testing GSR in the 90s. And he gave lots of reasons for that, agricultural, and that gunshot residue has too many false positives or even false negatives. And he explained that gunshot residue, I think he gave the example, if a gun is fired in a car, everybody in the car is going to have gunshot residue. If someone is wrestling an intruder covered in gunshot residue, that gunshot residue is going to transfer. If a person cleans their firearm, having not cleaned it since the last time he and his father went to the range to shoot it, and then doesn't change his clothes because you see the outfit he's in the night before these 3 murders and the same outfit the morning of the same murders, that would leave gunshot residue on his hand. The defendant fighting and struggling over a gun that goes off, that's already been fired multiple times, is going to leave gunshot residue on his hands. So gunshot residue is not going to prove or disprove any theory of this crime, other than it's going to exist where the gun has been fired that many times. If there was a struggle, it's going to be on him. If he's the shooter, it's going to be on him. State lab doesn't test for it anymore. Investigator Bosenberg testified that after having collected the gun and how it's wrapped and packaged and taken back to his lab, how it's unpackaged and how it's processed and how the firearm is super glue fumed. And he explained that there's this chamber that the firearm is put in, and then the fumes from the super glue attached to the oils or residue, whatever it is from our bodies that create fingerprints when we touch surfaces, and that he was able to get, for lack of a better word, 3 prints on this gun, and that he labeled those prints latent 1, latent 2, latent 3. He described latent 1 as the left palm print, and it was found from the left side, the left buttstock of this firearm, and that the quality of this print was good quality, not smudged, not drug.
But he couldn't do shit with it.
There were several identifying factors, and then he ran that through the system, and the system produced 5 names that this potentially could belong.
No, numbers.
5 numbers, identifying numbers. That
Oh,
this print, known latent print, could have possibly belonged to these 5 producers of prints, and that he compared them. And that in comparing them and comparing those identifying markers, he found identifying markers on the print from the gun to the first number that was produced by the system, and that number happened to match up to Alexander Jackson. And that then he took a confirmatory print, what he referred to as a known print, from the defendant, and he compared latent 1 to the left palm of the defendant and matched. He concluded that the palm print on the buttstock of the left side of that gun was the defendant's. And then he went through the same process, because on the right side of the gun, just a little bit before and ahead of the left print, he found a second latent, and he matched that to the identifying number that the system produced, and then took that and used the known print from the defendant that was collected and confirmed that the print on the right side of that buttstock, also good in quality, not smudged, not smeared, was the defendant's. Then he talked about a third latent print, that there are certain identifying markers that are significantly easier or more reliable to match to prints, specifically the prints come to curves or points, and that this latent 3 had mostly horizontal lines, and that he was unable to match or confirm that the horizontal lines or the latent from number 3 matched any of the 5 prints identified from the system. And he told us that that third latent was only about a centimeter big, that he couldn't find where those just striped lines or horizontal lines matched up to those 5 prints or the defendant's, but he couldn't exclude it. Just that it was poor quality, that it wasn't enough, that the identifying factors that he was hoping to see and look for didn't exist, and so he can't say it was or was not the defendant's. But latent 1 and latent 2 were good quality prints, big prints, palm prints on the butt of that gun in a place that would be atypical of a regular shot.
Get the gun out. Show me.
With where the gun would be held when the defendant shot himself in the foot with it.
Was he standing or sitting when he shot himself in the foot?
Ladies and gentlemen, Investigator Bosenberg testified that in
Got
this
a
house,
sketch for this.
there was not a lot of blood spatter. I think I spent that whole day calling it splatter and was corrected. It's spatter.
Haha.
There was some at the bottom of the stairs on the wall where Jan Jackson was shot repeatedly. I believe Investigator Bosenberg testified that there was minimal spatter around Jan Jackson's head imprint where his final resting place was on the carpet, that there was minimal spatter found in the hallway.
He wants to say splatter.
The defendant walked with his bloody foot along that floorboard area.
The floorboard area.
And then blood spatter in the defendant's bedroom. In the defendant's bedroom, the foot of his bed, next to that leg.
Lady, don't do that
ladies
again.
and gentlemen, that the spatter was found in the bedroom next to the bed, because that's where the defendant stood when he shot himself. He described as a fountain-like effect of his foot.
Yeesh.
That spatter left behind indicates just that.
Doesn't
Proves
sound
just that.
fun.
The defendant attempted to tie off his injury with a belt tourniquet, where he pulled that belt so high that the clasp of the belt popped off, and you see the belt over here and the clasp over here, right at that dark pile of blood where the defendant
like she's
stood and shot
rapping.
himself. What else is important about the evidence in that bedroom is that when asked
Where the belt popped off.
about making the 911 call, the defendant talks about how he made it just moments, seconds, 30 seconds after he got shot in the leg, and that he ran into his room to get the phone. But when you look at those footprints, those bloody footprints, they don't enter the defendant's room. They exit. They exit the room because that is the room where he shot himself. Not out in the downstairs living room where this supposed struggle with this alleged intruder took place. The spatter and the footprints prove to you, ladies and gentlemen, that the defendant was in his bedroom when he shot himself in the foot.
Did you say that though? Because I must have missed it.
Approximately 9 a.m. and 50 seconds in that interview video, the defendant said he thought it'd hurt worse. Getting shot in the foot, he thought it would hurt worse. That's
Yeah,
not
I didn't
something
hear that. Because I couldn't hear the video.
contemplated. You don't wake up and, gosh, I wonder what it would feel like to get shot in the foot by my own .22 Browning rifle. You think about what it's going to feel like to get shot in the foot when you've planned to try and cover up 3 murders that you've committed by shooting yourself in the foot, ladies and gentlemen.
Well, note to self. Shoot yourself in a more drastic place. Not the foot. She's almost done.
The defendant thinks he spooked him. I think I spooked him or something. Ladies and gentlemen, a common and reoccurring theme that you're going to find as you go back over your jury instructions is that in multiple places in those instructions, multiple different instructions, it says that you as jurors are to use your reason and your common sense. It does more than say it. It demands that you as jurors, when you go through this evidence and evaluate it and give weight to it,
This shitty
that
evidence.
you use
Ever.
your reason and common sense. And I submit to you, ladies and gentlemen, that as you process that evidence and as I sit down and Mr. Johnston stands up and then I get to talk to you one more time, that as you're evaluating everything that you've seen over the
Oh,
last
you're not
couple
gonna
of
let
weeks that's been
Doogie do
presented in this
anything?
case, using your reason and common sense,
Oh,
you're
darn.
going to find that the defendant's story does not make sense, that it is unreasonable to believe the story told by the defendant. And I'm asking you now, and I'm going to ask you again when I stand
I
back
wish
up,
you did there.
that when you go back and you deliberate
Unreasonable.
over this case and you process the evidence in this case, that you as jurors return verdicts, murder in the first degree, for the murder of Jan Jackson, the murder
Melissa Jackson
of Melissa Jackson,
and
the
Sabrina
murder
Jackson.
of Sabrina Jackson. Thank you.
All right, ladies and gentlemen, we're going to take a recess now. I think it's a good, before we start with the closing argument on behalf of the defendant, good time to take a approximately 15-minute recess. So again, I'd remind you of the admonition that I've given you. Turning it over to Mr. Johnston to make his closing argument on behalf of the defendant. Mr. Johnston, are you prepared to proceed?
Yes, Your Honor.
All right.
Yep.
Is
Is this okay, Kathy? Can you hear this okay? Check 1, 2. Yes.
Okay. You may go ahead whenever you're ready, Mr. Johnston.
Thank you, Your Honor. This is exciting.
Try this again. Okay.
Doubt is the absence of hubris. Certainty is the proof of it. Well, I don't know who made up that quote. I think what it means is that doubt is a natural condition. And doubt is what we ask of you as jurors when you evaluate the evidence in a case, is to look at it critically, use your common sense. Doubt, ask questions, because this is a case of circumstantial evidence. What that means is that even though the law makes no distinction, the evidence has to be so compelling as to remove all reasonable doubt.
Almost 2 years ago.
In other words, that there is no other possible interpretation of
plenty
this
of
evidence
time.
other than that the defendant is guilty. If there is any other possible interpretation, then the defendant is not guilty. And that is the consequence of a case based solely on circumstantial evidence. We heard Investigator Bosenberg, who stated under oath that he could not rule out an intruder. He was the one who investigated the crime scene. And although this is a horrific crime scene with 3 people tragically killed, it does not lower the burden of proof that the state must meet. So please do not let it inflame your passions or make you concerned that you should lower the burden of proof for the state
it
simply
does.
because 3 people were tragically killed in this case. Because there are 4 victims in this case, and one of them is Alexander Jackson.
Oh.
So, as you saw in some of the crime scene videos of the body cams of these officers as they moved through this house, this is a family that took pride in their family. They were a great family. They took great pride in all the vacations they took, all of the things that they did together, trips that they went on, accomplishments that the kids did, and the Eagle Scouts. Here's a picture of the family. There's Alex as an Eagle Scout. These pictures and pictures like this were all over the walls of this home. And as you listen to Ms. Slaughter this morning, the one thing that she didn't say is why. Why would Alexander Jackson kill his family? It makes no sense. This was a normal
I bet she'll say it
family.
in
This
rebuttal
was a
now.
happy family. There's simply no motive for Alex to do this. And no motive has ever been proven. When you look at what the state has to prove in this case, the judge has read the instructions and you've been handed them. Motive does not have to be proven by the state. They don't have to prove that. But when you try to make sense of the evidence in this case, you also have to do that in the context of this family dynamic.
So the jury can see him.
Why? Why would Alex do this? When he repeatedly told the investigators that he loved his family, that he wouldn't do this. Neighbors didn't notice any issues. Friends never noticed any issues. Teachers never noticed anything wrong. Scoutmasters never noticed anything wrong. They saw a family that participated in the family events, that interacted happily and normally together on the trips that they went on the scouting trips, and all the things of that nature. We heard testimony about Alex's character, that he went to Kennedy High School, that he graduated there, that he was accepted into the University of Iowa. He was an Eagle Scout. An Eagle Scout. Not just a Boy Scout, not a Cub Scout. He went on and went through all of the requirements for an Eagle Scout. He played flute in the top band. He was polite. He was respectful. He had no history of violence, no history of mental illness, and had never been in trouble before.
So then it's just a
When the prosecution
psychopath.
talked to you just a little while ago about his
Killed his
fingerprints.
mommy
They
and
only had
daddy.
his fingerprints because they arrested him. They did not exist prior to that in their files. When you look at this neighborhood and you think, as we heard, what goes wrong in this neighborhood. When you look at this neighborhood, if someone was going to do a home invasion, this would be the perfect neighborhood for it. It's affluent. Those are affluent homes. They're large. They're spaced out. The homes are spaced out away from each other. They're surrounded by wooded areas, and they're secluded, relatively secluded for an urban area. And as we saw, particularly in the Jackson home, the dog did not bark when the police arrived. I think
Which
on one of
is
those
weird.
cameras, you heard the dog go, "Woof." Just one time. If you listen
Oh.
carefully, you can hear it. But I
Guess what
don't
puppy
know about
does?
you. My dog goes crazy when anybody comes anywhere near the house.
She does. She goes, whoop.
There were no cars in the driveway,
Yes.
and there were multiple
The other one.
guns in this home.
Goes nuts.
We don't know what the intruder's intent was or why they were there.
I need to get the mail.
May not ever know. But it could have been because
Really
there were
doesn't like
firearms
the
in this home.
mailman or the UPS
There was a
man.
case years and years ago, which was the
FedEx
subject of a
or
famous novel,
somebody
In Cold
in-
Blood, where a home was
Why
invaded
is
in Holcomb,
that? Why do
Kansas,
they have such a
because of a
problem with
rumor that the guy kept $10,000 in the
I
safe.
like
This was back
the
in 1950s,
mailman
so that
and
was a lot
the
of money.
UPS and
And because of what happened in that instance, when these
no,
two
maybe
guys
not
went
the
in and killed
mailman.
everybody
Well,
in
they
that
bring
house,
Amazon packages
it became a
too.
very salacious story that Truman Capote wrote a novel about. These things happen. Home invasions happen. They happen, unfortunately, all over the country. And they happen for motives that we don't always understand.
Use a piggy.
There isn't a shred of evidence in this case that disputes anything that Alexander Jackson said happened. Alex said he was sleeping on the porch with his dog. There's bedding that was found in the porch. He was sleeping there, and he heard shots. That was his testimony. Now, was he sleeping? Was he on his phone? He was definitely on his phone at 6:53 in the morning, searching for who would play the Emperor in Return of the Jedi. Did he fall back asleep? Was he messing around on his phone? Did he drift off? Kids do that. But he was awakened to the sound of gunshots. And he had his phone with him on the porch. He hears the shots. Now, a lot of us would like to think in an emergency situation that we would act immediately. that we wouldn't freeze up, that we wouldn't be scared. But maybe Alex was. Maybe Alex froze. He hears the shots. He hears more shots. And he's afraid. And he hears somebody moving about through the house. He hears a number of shots. He estimates 10, I think, at one point. But you know, he's not counting them exactly. And he can hear someone moving through the house. And then it stops. So Alex either goes down the porch steps outside the house and comes back in through the back, or he comes around and goes down the steps inside the house. And what does he see? He sees a man standing over his father. And Alex runs at him, and a struggle ensues. Here's the important fact about the shell casings in this case, ladies and gentlemen. The first 4 were found, now we're assuming these are the first 4. Right there, right behind that area there is the back door. The back door should be right here. This is the back of that sofa. 4 shots fired in that area. That's where the gun drops those casings. 5 in the master bedroom. Got that one. It's okay. You remember from the testimony there was five shell casings found in the master bedroom. And there were 2 shell casings found in the sister's bedroom. What's that add up to? There's 4 of the 5 in the master bedroom in State's Exhibit 104. There's the 5th one in State's Exhibit 108. And then there was 2 shell casings. There's number 37 found in the sister's bedroom, Sabrina's bedroom, and number 19. That adds up to 11. Now the shooter is out of bullets. And I would submit to you that the order must have been when that person came in to the house. He sees the gun there. Does he have knowledge of firearms or not? We don't know. But he sees the gun there. We don't know how long it took him to load it, if he had to load it. If it wasn't already loaded, we don't know that. But maybe he has some knowledge of firearms, or maybe he took the time to figure it out. So we don't know how long he was in there before he was discovered. Jan Jackson is moving around. As the state said, Jan Jackson is awake. He sees the person or hears the person and comes running down the stairs. That's when the intruder fires off 4 shots at Jan Jackson, missing him 1 time into the wall. That's why those 4 casings are there. Then the intruder goes upstairs from the direction that Jan Jackson came and shoots the mom, shoots Melissa 5 times, shooting these people multiple times. That's 9 shots. He comes back downstairs to look for anybody else. And he goes past Alex's room. Alex isn't there because he's on the porch. But now Alex is starting to move. Alex is starting to come around to see what's happening. And he shoots Sabrina. He's going to shoot her 4 or 5 times, this intruder. But he runs out of bullets. He's only got 2 left. That's why she was only shot twice. That's when he goes around, he's reloading the gun. And why is he reloading the gun? Because Jan Jackson isn't dead yet. Jan Jackson is still making sounds. Jan Jackson is still breathing. So the intruder reloads. As he's doing that, he goes over and he shoots Jan Jackson twice. As he's standing over Jan Jackson with those additional shell casings that we find next to Jan Jackson's body, Alex surprises him. Alex comes up behind him, either from outside, going down the porch steps into the basement, or coming around from the stairs. I believe he must have come around from the basement.
Exactly how your client
That way,
told you
because
he
the
did it.
shooter would have his back to him as he's shooting the father. As he's killing the father, making sure the father is dead, that's when Alex surprises him. And that's when Alex gets shot in the foot with that struggle. Because the man has now reloaded. 2 shell casings
No,
are
I
found
would
on either
almost
side of
believe
Jan
it if
Jackson's
the
body,
gun wasn't so
and 1 shell
difficult.
casing is found next to the gun that's lying on the ground. But we could get to that next. I want you to look at this, where this foot, the hole is in Alex's foot here. See where it is? See where it is on his foot, because this is going to be important in a second. Can we go to the next shot then of the hallway? This is the hallway. This photo is State's Exhibit 72. You see this blood right here? This is where Alex got shot in the foot, not in his bedroom. The evidence will show that this is where he got shot, because this is where the gun is, this is where the shell casing is, but more importantly, the footprint. If we could zoom in on this right here in the middle of the screen.
I mean, the blood splatter.
Hold it up a little bit, please. Right here. Look at that print. I don't know if you can see it. That print has a foot with a hole in it and blood coming out. Right there, pointing in that direction. As if somebody got shot in the foot there with this blood here, and you can follow these footprints all the way down that hallway. There's 2 kinds of prints, ladies and gentlemen. When you look at the hallway photos, there's 2 kinds of prints. One before a shirt is put on his foot, and one after a shirt is put on his foot. And you can tell because there's a gap. If we follow down this hallway here, these are the 2 trails I'm talking about. This is the one where he already has the shirt on his foot. This is the one that is this one. There, 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 there. He is making his way to the bedroom to get a tourniquet for his foot. So he goes in to his bedroom. We have here, this is good. This is a close-up shot of that. There's the print with a bloody extra blood deposit where the hole was in Alex's foot. He's going this way. He's heading towards his room. And this is after he comes back out. This is his print with the
burning out up on the stairs. There's a whole body laying there.
This is the buckle, the belt that he used to try to make a tourniquet with, that he told the police, and it broke. Next picture, please.
Oh,
This is his bed. This is where obviously
I
the belt
hate
broke. There's a pool of blood here, which would have collected while Alex tried to put it
I swear.
on his foot. And this is obviously that blood bleeding out from that hole in his foot, right there where it was taken to rest on the side of the bed as he sat on the bed. Now, did he hop?
I
into his
don't
bedroom?
like it.
That's why there's not a print going in that direction. We don't know. But what we do know, can we get the next shot? Here, as you can see, after he's tried the tourniquet, after he's put a shirt on his foot, that happens. That print happens. Can you blow that up a little bit, please? See the gap here?
Nope.
The gap in the bloody print. That's where the shirt was wrapped around Alex's foot. Can we go back to the hall?
Oh, yeah. I could see that.
And now you see the effect of that shirt, and you see the gap on his footprint right there. Coming back this way to check on his father. How do we know that it happened this way? Well, we don't, but it's a fair interpretation of the evidence. Well, let's consider what the state thinks happened. Can we go back to that original shot? Is there another one that has a gun in it? There, right there. Are we to believe that Alex took that gun all the way into his bedroom, shot himself in the foot, then covered up his bloody foot with a tourniquet, and then picked up that gun again and drug it all the way back there and left it right there? That gun would be covered with blood. And it's not. There's no blood on this gun. This is where he bled. The gun falls here. There's a shell casing right there. There are 2 shell casings on either side of Mr. Jackson. And that's because that's where the killer was shooting Mr. Jackson when Alex.
But there's no bullet. They didn't find a
Otherwise,
bullet.
go back to that one again.
The bullet's not in his foot.
How else does this blood get here? If it wasn't from the conflict with the intruder and he gets shot, how else would this blood get here? Was Alex supposed to come all the way back up here with the gun and then stand there and bleed? Take the tourniquet off and bleed there? That makes no sense. That's the first print he makes after his foot gets shot, before there was a bloody shirt put on it. No shell casings were found in his bedroom. There was a shell casing behind the couch, number 13, which we talked
Because
about.
he had it in his hand
Now,
and brought
there
it
was
back.
a lot of testimony about no signs of a struggle. Well, there was no sign of a struggle either when Jan Jackson fell down the stairs and landed where he did. He just didn't fall into anything. We don't know if that couch was moved or not because they never picked it up and looked to see. Maybe it did. Maybe it got lifted up and it came back down. But there's nothing else to knock over right there. There's a struggle right there. And sometimes there aren't signs of a struggle. But there is a visible path from the living room to his bedroom. And the state's theory that he shot the sister first, which I think might have been raised earlier in the case, makes no sense. Because if you were to shoot Sabrina first, twice, you wouldn't run all the way from here, all the way past where Mr. Jackson would be coming down the stairs, all the way around this sofa to take up that position where those 4 shell casings were found. That doesn't make any sense. That's why what makes sense is those 4 shell casings by that back door is where the killer came in. That's where he came in. That's where he found the gun. That's where he loaded the gun, difficult as it may be. And then Mr. Jackson comes down the stairs and he shoots him. And again, the number of times that Sabrina was shot would indicate, I would argue, that the killer was out of ammunition at that time. And yes, we obviously would agree that that weapon had to be reloaded. On the 911 call, do we have that first? Can we play the first? I'll be impressed if this works.
La, la, la,
That's okay.
la, la.
We got it?
Oh, Jesus.
County Sheriff, where is your emergency? Someone broke into our house. Our address is 4414 Oak Leaf Court, Northeast. I've been shot. My other family member's been shot. I need help immediately. Okay, I'm getting Cedar Rapids on the line here. I've been shot in the foot. Okay, sir, stay on the line. Answering. Give them the address right away. What's the address of the emergency? 4414 Oak Leaf Court, Northeast. Okay, what's going on? There's someone broke in. Okay. I've been shot. You've been shot? My dad's been shot.
Okay. That wasn't great sound quality. But what he says on that first call is, I've been shot. My other family member's been shot. Now, the big difference between a possessive S and a plural S would be, if you were talking about all of your family members, you would say, my other family members have been shot, not my other family members been shot. That's the possessive use of the S.
Oh, and you
In
just
other
say
words,
my dad's
my
been
family
shot.
member, his father's been shot. And that's clear from the rest of this call. When he talks about he's been shot,
She don't even
his
believe
father's
it.
been shot. My other family member's been shot isn't a reference to everybody.
She's like,
It's a reference to
okay,
his
you're
father.
reaching.
You can tell by the context of the way that's used, and by everything Alex says after that. He talks about his father being shot.
Alex,
Doesn't
you
know
need
how his sister
glasses,
is.
bro. Stop squinting.
On the ambulance ride to the hospital, Alex was worried about his family. He says, my
What?
sister okay? And that's about the 8:56 mark. At the 8:59 mark, Alex says, did they get an ambulance for my dad? And at the 9 o'clock mark, did they get an ambulance for my dad? Again, he asks. And you can see that he is crying in the ambulance on the way there. Obviously, Alex is in pain. He's in shock. He's given fentanyl on the ambulance. The male paramedic says, okay, what number would you give that
On
pain?
the
10 being the
ambulance
worst
and
pain
the
you've ever
ambulance.
felt in your life. And Alex says, probably a 10. And again, Alex was given fentanyl, and we heard about what fentanyl can do.
Did we?
So then Alex is taken to the
I don't
hospital,
recall.
and the 4-hour hospital interrogation begins at that time.
Yeah,
This
that
is
was
a picture of
ridiculous.
Alex when he gets there at the hospital. You can see in his eyes the shock and the terror. You can see his condition with his foot. We heard testimony about the effects of trauma on memory, and we heard those from Investigator Denlinger, because he knows the effects that trauma can have on people's ability to relate a story rationally, and concisely, and appropriately. That trauma can cause confusion. Trauma can cause memory lapses, and we know that because the Cedar Rapids Police has that very policy for their officers. Officers involved in traumatic incidents must be given up to 72 hours before they have to make a statement to anybody. And that's because of the known effects of trauma on people's ability to relate things that just happened. Add to that the effects of fentanyl, which Dr. Cruz said can cause euphoria and can cause confusion. You add those two things together and you have somebody who is most likely disoriented and is not there, as Timothy Brown stated at 9:08 when he hands off Alex to investigators Denlinger and Lucina. He says, he's not there right now. And Sarah Lucina says, yeah, I can tell. And then at 9:29, the female hospital staff worker says, can I give him pain meds? And Sarah Lucina says, is your foot real bad? Do you think you can hold off on pain meds for maybe 15 minutes for us to talk to you? Can you imagine if you were Alex's parent in that situation? Would you stand for that? Would anybody stand for that?
Well,
Denying somebody pain medication while they ask them
parents
questions.
are
These aren't questions
no
designed to
longer
find out who the intruder was.
living.
These investigators were on Alex in minutes
That's
because
true.
they didn't believe there was an intruder.
They did
This is
not.
before they'd even been to the crime scene. This is before they ever knew anything about any cameras or dog tracking or anything. They were on Alex. Yeah, sure, they acted nice, but the most important thing is
His breathing
Alex
has
was nice.
increased.
Alex was polite. Everything that people said about Alex, he demonstrated in that interview, in that interrogation. He was polite to the officers. Even when they insulted him, he was polite to them. When they show up,
Yeah, that was kind of mean. They didn't have to be
this
so
is the
mean.
part about the fentanyl being administered. When they show up at 9:16 and start talking to Alex,
I mean, okay.
Sarah Lucina says, my name is Sarah, and I'm an investigator with the police department, and this is my partner, Matt. He's an investigator, too, at the police department. And Alex says, oh, good. He doesn't know what he's in for. He doesn't know the kind of grilling that he's in for.
He
And
doesn't.
then he gets another dose of fentanyl. And Alex says, what is that? And the female hospital staff says, fentanyl, the same medicine they gave you in the ambulance. 3 minutes later, under the influence of this drug, Alex says, my mom is here, or you can hear that at 9:47 on the interview. I asked investigator Denlinger, and he agreed that that's what Alex said. At 10:14, when it becomes obvious to Alex that they're directly accusing him of this crime, he says, I didn't do it, okay? I would never hurt my family. They're important to me. I love them. You may not understand that, but I love them. Then comes the false accusations about the cameras. Denlinger says, so at what point did you unplug the camera? Alex says, unplug what camera? Matthew Denlinger says, your camera. Alex says, I don't know how they work. They're also hooked up to the garage. I don't know. They're also wireless. Meaning, how can you unplug them? They're wireless. And then, in response to an allegation that the alarm system had been disabled, Alex goes, oh, there's no alarm system. There hasn't been for years. And Denlinger says, there hasn't been for years. At 10:09, Sarah Lucina says, and that's what I mean. That's why I want to know, is because you're adamant that you would never, but the evidence is pointing towards that you did. And Alex says, well, can't you do some lab stuff? He wants them to do more investigation.
Yeah.
He's not acting like somebody who just slaughtered his family.
Like you're
And here's the thing, ladies and gentlemen. He's in shock. He's under the influence of anesthetic drugs. And so it will be easy for people to sit back and say, I'd have been more upset than that. I'd have been crying more than that. I'd have been shouting out for my sister back at the house, Sabrina, Sabrina. He's been shot in the foot. He is in shock. He doesn't know what to do. But for us to sit back and Monday morning quarterback what he said and how he said it, when he's in this condition, when he's sitting in a hospital bed, bleeding out of his foot for 4 hours while they do nothing to help him, while he's been given pain medication, to judge his responses and the way he said them and the accuracy of those things is tantamountably unfair. We wouldn't require that of any of us under those same circumstances. And they chose to do that. They could have waited. They could have given him time to recover. They finally did after they made all their allegations and after Alex got treated at the hospital. But that was several hours later.
Not everybody understands.
And that's again where Alex is again about the lab stuff.
Right.
And Investigator Denlinger says, I mean, the best evidence in a case like this is not going to be the lab stuff. And Alex says, well, I think that helps. Apologize for the typo there. At 10:12, Alex says, well, I was because I went to my room to grab a belt, but it broke. So I wrapped it in the closest thing and
Whatchamacallit?
not to go get his phone, to go get a belt for a tourniquet. Now, maybe he said at a different part of his interview, I went to get my phone. But again, you have to put this in the context of someone who's just been shot, someone who's been medicated, someone who's been traumatized. Are they going to get everything right? I don't think so. But at least at one point, he said that he went to his room to get a tourniquet, and that is supported. That is supported by all that blood evidence in that hallway. And they said, okay, and then did you go into your mom and dad's room? No, I haven't been there for a while. Not once did Alex say he ever saw his sister or his mom get shot. At 12:19, Alex says, my parents were good to me. I'll say that now and forever. And that was at the end, more towards the end of this interrogation. But they kept trying to give Alex a reason. They were grasping at straws, trying to come up with a reason. Oh, you didn't like your sister. Oh, you weren't close enough with your sister. You didn't like your dad. You didn't like your mom. Oh, the Menendez brothers, they killed their dad and their mom. And then they later claimed it was because their dad was abusive. And Alex goes, I will never say anything bad about my parents. Alex described cleaning the gun that night. Well, I've got the ramrod thing. I know we put that back in at least I put it back in the exercise room. And Investigator Denlinger says a few minutes later, no, I'm talking about earlier in our conversation, you talked about you were not sure where you left the gun, but it wasn't on the fireplace. And Alex said, I think it was because my dad was still looking at it or something. And Investigator Denlinger says, you said the gun was not left out on the fireplace where you cleaned it. Alex says it was left. And Denlinger says, okay, it was left on the fireplace. And Alex says, yeah. At 8:53 p.m., after Alex was discharged from the hospital, he was taken to the Cedar Rapids Police Department. And that's again that's where he made the comment about his parents and that they don't usually lock their doors. And then Denlinger says, well, what's your sister's password for your phone? Is it Daddy favorite #1? Which was one of the last in a long line of disparaging remarks that Mr. Denlinger made about Alex during the course of that conversation. He said, who's going to support your Chick-fil-A habit? What are you going to do? Get a job playing Halo, being the #1 guy on Halo? And through all of it, Alex was polite. Through all of it, Alex didn't reciprocate. Through all of it, Alex denied killing his family and wanted them to do more investigation. Can't you look around some more, he said at one point. Can't you do some more investigation? We heard some testimony about the dog, Corsa. Corsa's a good dog. She's been trained. in tracking. She's been trained in explosive detection. And we had a dispute about whether dogs could smell disturbed vegetation or crushed grass. And Mr. Shear tried to ask Mr. Hyan about a couple of studies. Didn't show them to him and asked him about them. And Mr. Hyan had never heard of any studies that said that a dog can smell human odor and crushed vegetation. It doesn't really matter for this case. It's just an example of how Officer Buckles doesn't know everything that he's talking about when it comes to dogs. Mr. Hyan does. He's been doing it his whole life. He trains the police officers. He used to, before he changed his jobs to doing what he does now as consulting. He's been all over the world, Mr. Hyan. And he evaluated Officer Buckles' job of tracking and found a number of problems with how Corsa performed and how he handled that dog. Why does this matter? Why does this matter? Because if you're going to claim...
Why does this
track,
matter?
the absence of the thing, then you should do the tracking correctly. And it was Hyan's position that Officer Buckles did not do the tracking correctly. One of the reasons was the dog was panting so badly. And Officer Buckles' own training logs showed that Corsa had a history of panting, and that would interfere with her ability to smell. Corsa had no tracking experience over gravel. And if a dog can smell human odor, then you could track her over concrete. Did Officer Buckles once try to track that dog over concrete? No, because he knows. And this track is 40 minutes old at best. Now, Corsa did locate some tracks where officers had been before, but they had just recently been there. I mean, just recently, just within a couple of minutes. So that plus the fact that they had been through the backyard, as Mr. Shear pointed out, had contaminated the scene for a dog to smell an independent track. Dogs can't distinguish between one track and another, except in terms of the age of the track. And if the dog isn't on the track, it's not going to track. It's not going to be standing 20 feet away and go, oh, the track is over here. You have to bring the dog within range of its snout to do that. And yeah, obviously dogs can smell human odor. If you're right there, or if you've just left a room, they could do that. What Mr. Hyan is saying is they don't leave it on the track that you can smell 40 minutes later.
Howdy.
About the Ring camera. What we're looking at here on in this lower picture here is
I'd like
the Ring camera
my dog
recording the
to
police
tell me what
activity
she can and can't do.
on January 15th. Because all cameras showed police activity on that day except for the back camera. The back camera didn't show any of that. Why was that? That's what the police wanted to find out. Is the back camera not working properly? When the original warrant went out for the Ring camera system, it was supposedly supposed to be over a 3-day period, as the testimony said. But over a 3-day period, you get one view of the backyard over 3 days. Nobody in the summertime went out and was in the backyard of that house. There was already something wrong with this camera before we see the one with Alex in it. Maybe the camera was too high. It was up on the railing on the second floor. Maybe that outstripped its motion detecting. And so it had a sporadic motion activation system. And when Mr. Holst on the stand here, he said that all the cameras were offline when he subpoenaed the records for the 17th when they did that test. That's why they didn't return any data on any of the cameras, because they had gone off.
Turn Wi-Fi off.
That wasn't the case 15th. They were working. Some of those cameras were working. Do we have the video?
What do we need to see video for?
Stop that. So what are we seeing here? This is the day before. This was I think the testimony was late afternoon. There's Alex. This is the whole backyard right here. The camera is right up here. Right, that's the camera angle. Right in the lower corner. Camera would be just off of that picture. Alex doesn't even show up on that camera until right there. All of the activity that went on coming through the back door is way over here.
That's true.
Now, why does that matter? If we assume that Alex goes back to where he came from, we don't know because the camera didn't pick him up till he was way over here, where no intruder might have ever been. But if we assume that Alex came over here, can you play the rest of this clip and then the next one, please? There he goes. And then on the next one, you see him the whole time coming back. You see him the whole time. He's going right back up there where he came from.
That's fair.
The motion detector didn't catch that on the first shot. So there's something wrong with the motion detector on that camera. Now, they want to make the allegation that Alex messed with this camera. There's no proof of that. His prints weren't on the camera. There was nothing wrong with that camera. It had an image in it. There's no proof that Alex ever had the Ring app on his phone. And they tried to suggest that in the testimony, that Alex could have messed with the phone, with the camera with his phone. On the stand with investigator Denlinger, they tried to suggest that to you. Well, what have they done with that cell-right data since they had it on June 15th of 2021? Nothing. Nothing until they brought it up on the stand, and then we had our guy look at it. Then they decided they might want to look at it. But they'll make the allegation. They'll make the allegation that he messed with that phone without any evidence whatsoever to support that. And so then what happened? Investigator Holst went and looked at it and said the exact same thing our guy said. The same thing Mr. Lyon said. Here's the two incidents where the Ring app was last used by the parents. Nothing on the kids' phones, which would be consistent with the fact that the kids had nothing to do with the camera system. That's the parents that do that. And this latent print, number 3, which is shown here in Defendant's Exhibit G, that looks a lot bigger than a centimeter to me. But I'm no expert. It looks like we got at least 2 centimeters on there, and it goes way down here. Here's the thing about that latent print that we went around and around with Investigator Bosenberg about. It is one thing to say you can't match a print. It's another to exclude someone. You don't need the same amount of information. You need several points of comparison to say this is a match. But all you need is an inconsistency to exclude someone. Don't tell me that you didn't take that print and compare it to Alexander Jackson's to see if you could exclude him. That would matter. That would be important. And I believe that was done. It would make sense. It would be logical. And then he only submits this print for identification into the state database. What if this print is the print of the intruder? What if this print comes back to somebody who had no business being in that house? What if that happens 20 years after Alex has done 20 years in prison?
Well,
Are we going to apologize to him then?
yep. I'll get out in 20 years.
This print is very important and should have been pursued. Should have been pursued by people who want to know the truth. So the DNA evidence, you are going to hear me talk about DNA. And that's because you can get DNA from a lot of sources: sweat, blood, saliva, and touch. And why is that important? Remember, there was some discussion about that Idaho case. They found that DNA in one little place, and it broke the case wide open. If it hadn't been for that, investigators like Denlinger and Lucina would have been all over that roommate who survived, as if they were the one who had done it. Because there's no proof that anybody else was ever there. You have to look before you can say there's no proof. There is proof. There's proof in the physical evidence at the scene. There's proof on that gun. And maybe some of this DNA would have turned it up. But they don't want to know that. They don't want, that would be bad news for their prosecution. There were many areas on the gun that wasn't tested. And there was, they didn't even test the swabs they did of Alex. Not his hands, not his legs, all that swabbing that you see going on. They never test any of that. But most importantly, with the gun, with how many rounds it holds, that matters. That Nibin report that said that they were 22 shorts, if those bullets were 22 shorts, then you wouldn't have to reload. But we found out they weren't. They were 22 longs. Did the experiment. So what does that mean? That means that those 3 shells that were still in there that hadn't been fired had been touched by the killer. And those were never swabbed. They were preserved. They were dropped out of that gun. They were preserved, but they were never swabbed and never sent to the DCI. That is just like that Idaho case. That is the same kind of evidence. That sheath, that knife sheath
Why
that they
does
found
he
in that case
bring up
was
other
killer's.
cases?
So that little print
That's
on there,
not
whatever
even
they,
a case
however they
that-
lifted that off that snap on that
I
sheet,
don't understand.
belonged to somebody
I've
who
never
didn't
seen
belong.
that
That's how they
before.
broke that case wide open.
I mean, I saw today in the
They could have done
Murdoch
the same
trial,
thing
but
with the bullets in this case.
it was a trial. I mean,
Alex's clothes were
I don't
tested.
know. I've just never
Only
really.
Alex's
seen that
blood was
before.
found on his clothes. No blood from any of his other family members were found anywhere on
That's
any of
true.
his clothes.
And those are the same clothes he had on at 6:30 in the morning, and those are the same
There's some
clothes he had
testimony about a
on.
neighborhood canvas. And the court already read you the instruction on that. Officer Barber interviewed the workers, I think. Investigator Dunbar interviewed some neighbors. That's not evidence. What they said, those people said, is not evidence and is not to be considered. They didn't call these people as witnesses. They didn't call the workers. They didn't call the other neighbors. And so that evidence is not to be considered by you, what the officer said. It was only offered to show why the officers went to certain places.
But
But the
it's
substance of what those people said,
very surely
the
for the
testimony,
proof.
what the officers claimed those people said is not evidence. Remember when Investigator Dunbar was on the stand and he was talking about whether or not the people from Usher's Ferry ever got back to him? He was about to say they did, and then he corrected himself. And that's the reason why this kind of stuff is unreliable. But the court is specifically instructing you. If those people had testified, we'd have been able to ask them questions like, were you looking in this direction? Were you looking at that? What were you doing when all of this happened? And then the statements made by the police in their interrogations and their tactics, what they say to people, what you hear Investigator Denlinger and Investigator Lucina say, that is also not evidence. It's only to be considered in terms of Alex's response to those questions. We heard the state fish around in this case for some sort of a motive. Was it inheritance? They have no proof that Alex would inherit. They have not testified about a will, whether there is a will, whether there isn't a will, what it says, or whether Alex even knows. There was some question about the sister being bisexual, that somehow that would be something motive for Alex to kill his sister. Well, you hear Alex later in the interview when they start questioning Alex's sexuality. Alex said, I'm straight, but if I wasn't, my parents would be open to that. He says that right in there. It's not a motive. His grades dropping during COVID, that's a reason to kill your whole family? Or he didn't have a job? How many kids didn't? How many kids had their grades drop during COVID?
Well,
And Alex said that his father was treating him fairly, that his father was letting him make his own mistakes.
That's a valid point.
When I started off talking to you about reasonable doubt in this case, I gave you the Tylenol example. And the purpose of that is to say that even though a doubt can be small, it can be reasonable. And the only thing that you have to believe in this case to make that reasonable is that somebody could commit a home invasion and have some working knowledge of a firearm. And if that's impossible,
I mean, COVID started
that's your decision,
a
I guess.
year prior, but
Because
I
you
mean,
are the
we
judges of the facts.
still in it.
That's why we stand up when you come in, and we stand up when you go out.
So
Because nobody
life
can tell you
still hard.
what reasonable doubt means to you. That's why we have 12 of you. You're all going to have different attitudes. Or
I mean,
opinions.
that's what.
But when you look at a case that involves circumstantial evidence, if all you got to believe is that somebody broke into this house and used the firearm that was sitting right there, and they knew how to operate it, that's not such a stretch. That's not so hard to believe. Maybe it will be for some of you, and that would be your right to feel that way. But would you be betting would you take that Tylenol? If that's all it took? Are you taking the Tylenol out of that state's case in this case? Because if you're not, that's reasonable doubt. We believe that reasonable doubt is all over this case. Alex had no reason to want to harm his family. And we would ask that you return a verdict of not guilty. Thank you.
Ladies and gentlemen, before we proceed with rebuttal, why don't we just stand up real quick?
Aw, you're putting them to sleep. Oh, I gotta.
Right. Ms. Slaughter, do you have a rebuttal argument you wish to make? All right, you may go ahead. Do you need the AV system? Okay. All right, well, just let me know, obviously.
Boop-a-doo-boop-boop-boo-doo.
This is a case of circumstantial evidence. That's what Mr. Johnston said when he stood up here in front of you. I don't disagree with that.
She's angry now.
DNA itself is circumstantial evidence. It says that someone's DNA is there, but it doesn't tell you how it got there, right? That's what circumstantial evidence is. It's evidence that does not have that direct source that someone's going to sit up there and tell you that they heard it, they saw it. That doesn't make it any less effective or any less true or mean that you give it any less weight. We said that in the beginning, that you as jurors get to evaluate the evidence, and that you get
But
to
it tells you whose it is.
on any one given piece of evidence that you want to put on it and use that to paint the picture. There's circumstantial evidence in this case because no one else was there to see the defendant murder his family. One important factor in this case that everybody keeps talking about is evidence and what evidence existed. But let's not forget that the absence of evidence is also evidence. And ladies and gentlemen, there's a whole
That's
lot
fair.
missing
You
on
don't.
those cameras.
have to
And
get
there's a whole lot missing from
angry.
those cameras because there was not an intruder. The defendant wants you to believe, ladies and gentlemen, that sometime during the early morning hours of June 15th, 2021, the black guy in all black with a ski mask and gloves and green shoes is lurking around this secluded
That's
cul-de-sac
where you
full of
messed up,
affluent
dude.
people who are out walking their dogs and enjoying their morning, and no one saw him. And no video cameras picked him up, including the 4 video cameras attached to the Jackson home and the camera across the street that live streams everything. It doesn't stop. Investigator Denlinger told you that he watched 6 hours of footage from the Nest camera from the Yang house, and there was nothing. We can go back and forth about what happened to the
Yang
backyard
house is
camera.
very far away.
We looked into it. We can't prove it one way or another. It's very coincidental, though, that the one camera in the Jackson household that could confirm the defendant's story about the random black guy in all black with green shoes and a ski mask and gloves made it to that back door and didn't get picked up on the camera that caught Alexander Jackson walking the exact same path the night before. I don't know what happened to the camera. We couldn't prove it. Had experts look at it. They analyzed it. For whatever reason, it didn't work. But that's coincidence. None of the other neighborhood cameras found this person. And then Mr. Johnston stands up here, and now the story is that when the defendant heard the gunshots, he ran out the back door and came down the steps and then went around to the back door and in, and that didn't pick him up on camera either.
Because they didn't pick him up
Mr.
till he was
Johnston
all the way down here.
made a big
He went
deal
down the
about the
thing
state
and the door.
not being able to prove motive in this case. When you look at your jury instructions and you look at the elements of the crimes that the state is required to prove,
You have to prove
motive
motive.
isn't on there.
Jesus.
Motive isn't on there, and the state is not required to prove motive. We can lodge some guesses. He talked about being the kid home from summer vacation and his dad wanting him to get a job and him getting ready to be kicked out of the house. And if he doesn't have a job, then he's out with $30 in his bank account.
His dad wasn't going to do that. He
The
knew that.
oddball of the family, the black sheep of the family who stays up all night gaming with his
Black
friends is suddenly
sheep
going to have
of
to
the
step into
family.
the real world and get a job and be a man. Motive? The fact that he only has $30 left over, is money the motive? Is the fact that he's going to inherit houses and assets and all of that, is that motive? I don't know, but guess what? I don't have to prove that motive. No matter what motive, no matter what reason that the state would present to a group of rational-minded jurors is never going to be motive enough for you to think, gosh, that's a good reason. That's a good enough reason why this kid killed his parents. There's never going to be a good enough reason why Alexander Jackson executed his entire family. Mr. Johnston wants to talk about murder cases that happened in 1959 and, motives there. And how many murders do you hear in the newspaper or on the news as his source where there's never a motive why a school shooting happens or why this or why that or why some kid decides one day that he's going to walk into a building and execute kindergartners? It's never going to be a good enough reason to kill your whole family.
Good Lord, ma'am.
That's why we don't have to prove motive, because it's irrelevant.
That's not always irrelevant. It's just nice to have.
The defendant on this fentanyl is so doped up and euphoric that he can't form thoughts. Ladies and gentlemen, you get to see and hear how the defendant responds and how the defendant reacts when he's at home laying in that hallway with his foot wrapped up. You get to hear his tone of voice. You get to hear how he answers every question with a question and the weird inflection in his noise. That doesn't change before the fentanyl or after the fentanyl. The idea that 320 pounds and 100 mgs of fentanyl is going to make him so ill-lucid that he cannot form rational thought and he can't explain to you the details that just happened. My family was just executed. My dad is laying in front of me in a pool of blood with gunshot wounds, and I can't tell you any more than that limited information that he just gave. That makes no sense, ladies and gentlemen.
It's very passionate.
The only person that Alexander Jackson was worried about on June 15th was himself, because he slips in a couple sentences. Is my mom okay? Is my sister okay? He never had concern for his father. He never checked on his sister. He never checked on his mother. He never called out their names. He never crawled an extra 4 inches to peek around the corner to see if his sister, whom was laying in bed, was okay. Never tried to resuscitate his father. Never shook him. Never told the 911 caller, listen, it's just my foot. Who cares? My dad is laying here dying, if not dead. The only person that Alexander Jackson cared about on June 15th was himself, ladies and gentlemen. And that's because he killed his family members. He has to make himself look like the victim. There's 4 victims in this household. There's 3 victims in this household and 1 murderer. And that murderer is Alexander Jackson.
This is what? Oh, okay. Shit.
Mr. Hyan.
She's angry.
Mr. Hyan, basically took the stand and said that none of the K-9 units used in police agencies across the United States are any good, because that's not how he learned it in Germany back in the 1990s.
I mean, that is kind of what he said.
He doesn't think that he should be certified in any of the certifiable programs that are used by law enforcement agencies across this country, because he just doesn't think they're good enough. If you look at Mr. Hyen's CV, his curriculum vitae, which is the same thing as a resume, any notable experience that he had was in the 90s. 90s doesn't sound like that far away when you think about it, but that's over 30 years ago. He wants to say, oh, there's a couple things missing from the early 2000s, but he also said that if it's not written down, it doesn't exist. You can't even keep your resume up to date, and you're coming in here testifying as an expert witness because some dog class that you took in the late 80s and early 90s tells you that German dogs do it better than all of the police forces in the United States do it. It's a joke. He contradicted himself so many times that I don't even know what his testimony was. In 1 minute, he's saying, this is where the entry point to the backyard should have been. This is where Officer Buckle should have started that track. And then he points at the area that was most heavily contaminated by EMTs and law enforcement agencies. And then he says, well, the dog can't smell human odor. The dog can only pick up vegetation. It's too hot for the dog to do any tracking. Wait, ladies and gentlemen, right here, Officer Buckles is pulling the dog away from a verifiable scent. You can see the way the dog puts their nose down that they smell something. Well, which is it? The dog can't smell or the dog can smell? Then he says,
He was saying she could.
again, you know, as the dog gets closer to the house, it's too hot. And I quote this, it's too hot. It's dangerous for the dog to be working in this heat. Not 2 seconds later, he says, look how the dog picked up that track, but we're not going to count that track because that's a contaminated area where the officers went. Dogs can't track across concrete, and dogs can smell illnesses. Dogs find people buried under rubble after explosions. Dogs do all these amazing things, which is why they're used. But because Mr. Hyen got a training class in the 90s from Germany, we're just supposed to discredit all of the K-9 work, both medical and emergent and law enforcement that K-9s do in this country because Mr. Hyen said it's not good. Stop it.
She said, stop it. Girl said, stop it.
The common sense
Oh,
that Mr. Johnston talked about, that I talked about, the version of events that the defendant wants you to believe in this case is an insult to common sense and to reason. The defense stood in front of you and talked about if there's two differing stories, then that's doubt. I submit to you, ladies and gentlemen, that in any criminal case, unless you were there to see it yourself or the entire crime was captured on video, there's some doubt, and there should be. And that's what you as rational and reasonable and commonsensical jurors get to analyze and decide. But reasonable doubt, and we talked about this in Vordaer, reasonable doubt is more than the mere possibility of doubt or the mere possibility of innocence. Possibility doesn't make something reasonable. What the defense wants you to believe in this case when they're arguing reasonable doubt.
she's hated.
In order for that theory or those theories to create that reasonable doubt is a couple things. First, for the defendant's story to make sense, what Alexander Jackson told police officers and EMTs and 911 operators is that on June 15th, 2021, this intruder gets into the neighborhood, whether coming from Usher Ferry Road or from Oakleaf Court, up Scarlet Court, whatever that street is, that this intruder makes it into the neighborhood, into the backyard of the Jacksons, and he is not seen by anyone or any cameras. Nothing picks him up.
His
And that in picking
invisible
this random house
ninja
that is secured by cameras, but not by locked doors, that he picks the random house with the back door unlocked. Even though on the video camera, the front door is locked, the garage door is locked, all doors are locked in this house, except that basement door.
Oh, she's mad.
Coincidental.
Oh, she said, fuck it.
Then you have to believe
Lucky.
that this armed intruder came into this house for one of two purposes. Both of those purposes fit into the definition of burglary, which is why that word's been thrown around and why the defenses keep saying to you, no one said burglary, did they? But when you break and enter into a house with the intent to either steal something, commit a theft, or commit a felony within, that's a burglary. That's where that word comes from. So what you would have to believe as jurors that this burglar, this intruder, makes it into this backyard, isn't seen, finds the house surrounded by cameras, one coincidentally off, picks the door that isn't locked, and comes into the house to either steal stuff or hurt people. Now, we're going to break into a house and want to steal things, whether that be guns or jewels or money or whatever, and we don't steal anything. Nothing's stolen, nothing's ransacked, nothing's gone through. Okay? Or you're breaking in to hurt someone, but then you don't bring your own weapon. So, after we've made it to the backyard and to the house without being caught on camera, and we find the unlocked door, and we go in with this intent to do one of the two things, there was the proposition that, well, maybe he's in there to steal guns. Maybe he is. Or he's in there to hurt people. No weapon. Even the 911 operator, you got shot with your own gun? And then you find this gun to which the defendant said was unloaded and left on the fireplace from the night before. A gun that the defendant went out of his way to say was his father's in a tribute to his dad. It's my dad's gun. It's my dad's gun. I'm not sure where we store it. You store it under your bed because it's your gun. The box that this is stored in is stored under your bed, and it is stored in two pieces.
That's true. It is.
The other guns in the house were in the master bedroom or locked in a safe that there was no key to. This gun is the defendant's gun. It's his .22 Browning rifle, semi-automatic. It's his Eagle Scout gun, ladies and gentlemen, that he's comfortable with. In the hospital, he's even explaining how he cleans it and takes it apart because that's the gun that he's familiar with. Box under his bed. So the defendant comes in, and the only in one box, according to the defendant, of ammunition that this family owns for this gun is also sitting out neatly next to the gun on the fireplace mantle, and this burglar or murderer or whoever just loads this gun and goes on. And in no specific order, assassinates and executes Sabrina Jackson, assassinates and executes Jan Jackson, goes upstairs, assassinates and executes Melissa Jackson.
Dad helped
comes back downstairs
clean the gun that he used
with at least
to murder
4
him.
bullets in this gun, ladies and gentlemen. The defendant, after hearing all of these gunshots, wakes up and runs downstairs. We're supposed to believe he went out the back door and in. And runs into this intruder and pushes him and wrestles with him and struggles over this gun, leaving only perfect quality palm prints on the butt of this gun that they're struggling over. And the defendant
I said they were good quality.
gets shot in the foot. Then he says he falls. So after the struggle and the pushing and him getting shot in the foot, he says he falls down. And you can picture this in your head, right? That this intruder is standing over the defendant who's laying there bleeding from the foot. Point blank range, like the intruder likes it, right? Like he executed Melissa Jackson and Sabrina Jackson and put 2 in the back of the head of Jan Jackson. He's standing there with the defendant on the floor. And then he just decides, you know what? I have reached my kill quota for the day. I'm going to let this guy live. The one guy who can identify me, the one guy who struggled with me, the one guy who's going to be able to call the police. We're just going to let one shot to the foot is good enough for him. We're going to leave that guy alone with 3 bullets left in my chamber. And then I'm going to put the gun down and I'm going to run back out the back door. Nobody's going to chase me. No one who's trained in rifling through the Eagle Scouts is going to pick up that gun and fire any shots in my direction. Is not going to hoop and holler for help. Is not going to follow me out the back door. Nothing. I'm going to put the gun down and I'm going to leave out the back door. That's where the intruder went.
Stop it. Oh,
That
just another stop it.
Zero common sense. Zero.
Oh.
Mr. Johnson stands up here and suddenly he's an expert in bloody footprints and void marks, and there
Well, are
any
you?
bloody footprints going into that bedroom where the defendant said his phone was. There is blood spatter in there, There is a deep-seated blood spot next to the bed where you see those spatter marks. There's no shell casing in there. There's no shell casing around the other dark spot behind the couch. Both of those areas, and you see them in the photograph, and Investigator Bosenberg testified to, were cut up, and there's no bullet. Do remember what the defendant was playing with when the officers had that oh crap moment and realized that they'd left the defendant downstairs unattended with a loaded gun. When they came back down those stairs, the defendant's playing with a shell casing.
Yeah, when they had that oh fuck moment. We probably just left the murderer downstairs with a loaded gun.
The shot didn't hurt as bad as he thought he would.
But they were real
The
concerned.
defense, ladies and gentlemen, stood up here and clicked through a bunch of family pictures and accused the state of trying to inflame the passions of the jury.
Objection.
You're smarter than that. They want you to find some significance and some relevance in the fact that when Sabrina and Alexander Jackson were little and they went on a bunch of family vacations, that this family was happy.
Again,
I'm sure they were.
nobody has recent
I hope they were.
printed out photos. Nobody does that.
What you don't see in any of those photographs or any pictures that are recent of this family, and you ask yourself what goes on behind closed doors and you don't know. No recent family photos. And witness after witness after witness that the defense put up, they did a good job of testifying about the defendant's character 4 or 5 years ago.
That's
The same
true.
4 or 5 years ago, if
Well-
not more, that you see in these photographs. There aren't recent family pictures of the Jacksons hanging on those walls. The only recent pictures of the Jacksons are then laid out on a cold slab in the medical examiner's office
Oh, damn.
because the defendant murdered his family, ladies and gentlemen. That's the only scenario in this situation that makes sense.
No.
That's the only scenario in this situation that is supported by and consistent with the evidence that was found. This was not some random intruder that breaks in and executes a family that he doesn't know with a gun that he didn't bring with the hope to steal things that are never stolen, where there's a struggle with a huge man and a tall man, a black man with green shoes wearing all black and a ski mask with gloves on. Makes no sense. The murderer in this case that you're looking for, ladies and gentlemen, is seated right behind me. And that murderer is Alexander Jackson. And I submit to you that when you go back to deliberate this case and you look at the facts and review the evidence and check the cameras and watch them yourself and listen to calls and judge and give weight to everything that you've received in this trial, there is only one conclusion that you as jurors are going to be able to reach, and that is that this defendant is guilty of all 3 counts of murder in the first degree. Thank you.
All right, ladies and gentlemen, at this point, I'm going to read to you the remaining, I believe, 4 jury instructions. Starting with instruction number 36. During the trial, you've been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect a recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict,
Yeah,
leave the
she,
notes in the jury room and they will be
she
destroyed.
killed
Number
that.
37.
She was
Exhibits have been admitted into evidence and
super
will be considered along with all the other evidence to
upset.
assist you in reaching your verdict. You are not to tamper with the exhibits or their contents, and each exhibit should be returned into open court along with your verdict in the same condition as it was when you received it. Instruction number 38. You may not communicate about this case before reaching your verdict. This includes via cell phone and electronic media such as text messages, email,
She
electronic messaging applications, and any social media
definitely-
platform, including but not limited to Facebook, LinkedIn, YouTube, Twitter,
my
Instagram,
God.
Snapchat, and any other social media applications you may use. Do not research or make any investigation about this case on your own. Do not visit or view any place discussed in this case. Do not use internet or application-based maps or programs or any other application, program, or device to search for or view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, witnesses, lawyers, or myself. This includes using the internet to research events or people referenced in the trial. This case will be tried on evidence presented in the courtroom. If you conduct independent research, you'll be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information, and that has not been
the
tested by the
amount
trial
of
process, including the oath to tell the truth
shitty
and by
police work
cross-examination.
and
All the
shit
parties are
they
entitled
had
to a
to
fair
deal
trial
with.
rendered by an impartial jury, and you must conduct yourself so as to maintain the
She
integrity
did
of the trial process.
relatively good
If you
job.
decide a case based on information not presented in court, you will deny the parties a fair trial in accordance with the rules of the state, and you will have done an injustice. It is very important that you abide by these rules. Failure to follow these instructions may result in the case having to be retried and could result in you being held in contempt and punished. Instruction 39. When you begin your deliberations,
wish
you should
the
select a
other
foreman or
lady
forewoman. He or she shall see that your
would have
deliberations
done
are
the
carried on in an orderly
closing,
manner, that the
but
issues
I
are
think
fully
the
and freely
reason she
discussed,
didn't
and
do
that every
the
juror is given
closing,
an opportunity to
the other
express his or her
defense
views.
attorney didn't do the
In order to
closing
return a
because
verdict, each
she
juror
hadn't
must
been
agree to
there
it. Your verdict
a
must be
week.
unanimous. When two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact
But
leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based.
I think
It is
she
your
would have
duty,
done a better
your
job
duty as
than
jurors
him.
to consult with one another and
I mean,
reach
he
a
did all right
verdict
in
if you
some
can do so
spots,
without
but
compromising your individual
I
judgment.
mean, he's real
Each of you
snarky.
must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong, but do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are not partisans or advocates. You are judges, judges of the facts. Your sole duty is to find the truth and do justice. Occasionally, after a jury retires to the jury room, the members have questions.
mean,
I have prepared the final instructions only after carefully considering the evidence presented in the case with the lawyers. I have tried to use language which is generally understandable. Usually your questions about the instructions can be answered if you carefully reread them. If, however, you do find it necessary to ask a
I
question
don't know. This
about
one
the
would be a
instructions,
hard one.
you must do so in writing. I cannot communicate with you without first discussing your questions and the potential answer with the lawyers. The court attendant who works with you in this case from now on is in the same position as I am. She will take an oath not to communicate with you about your deliberations.
This
She
one
has not
would
spoken to you during trial
be
except about the mechanics of being a
a
jury.
hard
She will not speak to you
one.
when you have retired to deliberate, except to ask you for
Okay,
agreed
I
upon
don't
verdict.
care
And to
about the
manage the
rest of
logistics,
them.
folks are going to be free to leave at that point. However, they are still
They're gonna
those
pick
aside so that
alternates.
you can, if we had to
A
resummon
little
summon.
tumbler box. What's this? Oh, he's gonna make the
I don't know when
motion.
they're going to be out of there, so I will just start.
Middle.
Your Honor, we had a bench conference during Ms. Slaughter's rebuttal argument. I made an objection about her using the terms, that's a joke, and stop it. And then after I made that, she said something was an insult. And I objected to her personal commentary on the case. And that it was clear that her entire argument was her own personal opinions on things. She never once said the evidence shows or doesn't show. And because of that, Your Honor, we move for a mistrial.
Oh,
Ms.
please.
Slaughter, Mr. Shearer.
Obviously, Your Honor, we're resisting the defendant's motion for mistrial. Closing argument is the one place where the state is allowed to be argumentative. The rest of his argument is without merit. We're asking you to overrule and deny it in its entirety.
All right. The only two statements that the court was made aware of during the bench conference, and the third one occurred after the bench conference, but was the, I think,
Stop it.
referencing a joke and stop it. Again, I would agree that those statements are questionable, but in the scheme of the overall argument, I don't see that there's any
I'm gonna ask for a
sufficient prejudice
mistrial.
or to the defendant that a
You
mistrial
are
would be
petty
warranted.
as
So,
fuck.
for those reasons and the reasons articulated by Ms. Slaughter, the motion for a mistrial is denied. Other than that, is there any further record to be made at this point, Mr. Johnson?
Can we approach the bench, Your Honor?
You may.
Why? There's nobody in there. Just fucking talk, man.
So, okay, well, all right. Well, let's just go back on the record. So what I'm going to ask is that a representative from, at least one representative for each side, maybe meet with Kathy and go through the exhibits, make sure we're all on the same page about what exhibits are going back to the jury. My understanding is that I think the record reflects the defendant had to scan, counsel for the defendant had to scan in some of the exhibits. Some of them may not be here right now. They need to get here quickly. And so we can send those back to the jury. But before we do, again, I think the attorneys need to conference and make sure there's no disputes about what we're sending back. If there are, let me know and we'll address it as needed. And then I'm just going to ask for a phone number, how I can get a hold of everybody, and we'll call if there are questions and from the juror or when we get our verdict. I will email both of you, both sides, kind of the stock end of the day instruction that I give to jurors, you know.
That is all. That was all of that day. So we are going to jump right into it. Hold on. So what do we think? Guilty, innocent, guilty, innocent? Anybody? I'm going to say guilty just because, well, we already know that people are going to say guilty, and she killed it. So, and quite honestly, I mean, I was thinking about this today after watching the Alex Murdaugh trial. Like, they're going to convict him just because of who he is. The state hasn't really put on a good case for him either. It was like shitty police work, and they did some real shitty things today on the prosecution side to get to be sneaky, and that's just how it's gonna go. And like, people are just gonna juries are what juries are, and they don't have anybody else to blame, so they have him. They have a fingerprint. They don't have anybody else. There was nobody else even questioned. No, the defense didn't bring up that there was anybody else that was questioned. Like, there was nothing else. So here is the verdict. He's just sitting there. Could you imagine having to sit here and wait for the jury to come back to tell you, like, what you're going to do with the rest of your life? I couldn't. Like, that's crazy. He was sitting there, just chilling like a villain. Oh, we're not gonna hear courtroom. We got no closed captioning. Who does he look like? Who does this defense attorney look like? I don't know, but he looks like... I wonder if these are public defenders. What could it be now? Put your phone away. Put your phone away. Oh my God, come on. The judge came in. Like, I almost wonder, like, if they, like, prep them and just be like, okay, so if you're convicted, She looks. He likes her. I wonder what they're talking about. I want to know. I wish I could read lips. Well, he's not even moving his mouth for real. She is. He didn't even open it. He's sad. Yeah, he doesn't have a good feeling. See, but watching the Alex Murdoch trial, he's been crying and pitching a fit this whole time. Like, he has been an emotional wreck. Like, you don't ever really see that. What is that, the jury? Oh, I was about to say, y'all better stop that. That's not it. Just more of the people. I only got one mic. Oh, lighting in there is fantastic. Rise. The Honorable Judge so-and-so. You should be all zipped up before you come out the door. Are we going to say a prayer? I bet you that's what he does. He does that before he starts. They're all nervous. Can we move along? Shit. What are we doing?
The Iowa District Court is now in session. The Honorable Judge Mark Anderson.
All right, go ahead and have a seat, everybody. Okay, we are back on the record. We have our jury present, counsel, Mr. Jackson present. Members of the jury, has the jury reached a verdict in this matter? All right, if you would like to, are you the foreperson? All right, if you'd like to hand that to Terry. All right, would the parties please stand?
No. I would not like to.
All right, as to each of the three counts, form of verdict 2 has been executed. We, the jury, find the defendant, Alexander Jackson, guilty of the offense of murder in the first degree.
Damn.
And just ask you individually, are these the jury's verdicts? All right. Ladies and gentlemen of the jury, at this time, I'm going to excuse you. I'm going to ask that you go with Terry and go back to the jury room. I will be back in just a little bit and have a chance to talk to you before we excuse you. But at this point, we'll excuse you and ask that you go back to the jury room for a few minutes, okay?
All rise.
All right, go ahead and have a seat, everybody. All right, again, we've excused the jury. At this point, based upon the verdicts entered, I am setting this matter for a sentencing hearing. Sentencing will be held on March 3rd of this year at 1:30 p.m. Mr. Jackson, I need to advise you, sir, that you have a right to file both a motion and arrest of judgment and a motion for a new trial. Any such motion must be filed no later than 45 days from today's date, but in any event, not less than 5 days before the date set for sentencing. If you have questions about either of those motions, your attorneys are the people to talk to. No PSI is ordered because these verdicts all involve Class A felonies. To the extent there are existing bail provisions, those bail provisions are revoked. No bail is set, again, as these are now non-bailable offenses. And I believe that's everything we need to address on the record. Is there anything further we need to address on the record at this point on behalf of the state?
No, Your Honor.
Mr. Johnson, on behalf of the defendant?
No, Your Honor.
All right, then we are adjourned. Thank you all.
Damn. Oh, they're not even gonna smile in the courtroom. It's the first time I've seen him in handcuffs. Wow. That's crazy. See? That's why I say Alex Murdaugh, he ain't got no chance. That man, listen, that man is on trial for murdering his wife and son, and he's accused of stealing lots and lots of money and whatever. Yeah. That town don't like him. You know, the jury don't like him. And they got the political. Come on now. This boy didn't have nothing. And they got him. But I mean, honestly, a reasonable doubt. Okay. Think about it. A reasonable doubt. Could there have been an intruder? Could there have been something that took place? I would probably lean more towards yes. If they would have brought their own weapon, maybe. But if the gun is so difficult to deal with, but maybe, I mean, it is Iowa. People probably have more gun knowledge than most. But I mean, how common is that gun? And could they figure it out that fast? But also at the same time, I just really felt like it was really shitty police work. Like they just were like, yeah, we got him, so we don't need to do shit else. That's the same with the Murdaugh case. They got him and they don't have to do shit else. So like that shit irritates the fuck out of me. So just to be difficult, I don't want to say guilty. Because y'all didn't do your jobs. You just said, because I said so. That's why they're guilty. So, anyhow, that was that. I just want to know why now. Like, but you're not going to get a why because he's going to appeal it because he doesn't want to do all that time for 3 first-degree murder convictions. But then, see, that's why, I like when they find the real serial killers who admit to doing the shit that they do, because then they're willing to talk about it. I don't like the ones that are like, no, I didn't do it. I didn't do it. Bro, if you did it, just say you did it. And then tell me why you did it. Like all this, no, I didn't do it. I didn't do it. They caught you with all of the things. You did it. Now just tell me why you did it. That's why. I'm nosy. I want to know why you did it. Homie. Like, Alex, homie, why'd you do it? What did your dad do? What did your mama do? What'd your sister do? Did you really think that you were going to get away with it and get all the money? Did they have some life insurance plans? Like, they didn't bring out any of that stuff as a motive. Why wouldn't they? Because he didn't know about it? Why? I don't know. They didn't bring out any motive. That's the fucked up part about it. If you have a motive, let me know. I'm more amped to believe when there's a motive. If you don't have a motive for me, I'm gonna be like, well, then why the fuck did you do it? I don't believe that you would do it. Why would you do it? I would have easier time believing some stranger off the street came in and took his chances trying to rob some shit out of this nice ass house than lazy ass son over here. But I don't know. All right. Anyway, that's it. That's all. Now I have to figure out what else to do. We'll see. All right. Well, thanks for joining. And I didn't say it at the beginning, but like and subscribe and hit the notification. And then that way you'll know when I put out new videos and you can watch them with me. And yeah, it'd be great and fun and wonderful. Okay. All right. Have a great night. Where's my mouse? Oh, there it is. Okay. Bye.